For those of you who have not been with us before, I want to make sure everyone is aware that you are not able to have your cell phones out and in use at all. And so if you have a cell phone, if you would kindly turn it off and put it away. The only persons that are allowed to have their cell phones, as we have talked many times, of course, are the attorneys who are at the table, the media who have been granted access for the purpose of business only, and any attorney who's in the courtroom who has business in the courtroom and needs to, of course, look at their cell phone to see when they need to be in court. And so with those exceptions, everyone else needs to make sure their cell phones are away. Law enforcement, of course, can have their cell phones. All right, Mr. Yelman-Chile, Mr. Bolden, anything from the state before we get started? The jury is here.
Judge, just briefly, when we ended yesterday, I did not think that we would necessarily reach playing Mr. Faust's statement today, but it does look like we may get to that point this afternoon. I've spoken with Mr. Cruz this morning. The way that the two parties have done timestamps differently, the state's timestamps correspond to the time that is displayed at the bottom of the video interview, and the timestamps in Mr. Cruz's transcript just start at a 0 and move forward in time since then. So if the court were willing, after the state's first two witnesses of this morning, I believe, if we could take maybe a little bit longer lunch break to allow Mr. Cruz and myself to go through and make sure that we have timestamps that connect or correspond correctly. I think that's important and certainly needs to be done, and for the court to hear if there's any kind of disagreement between the parties and what may be admissible before the jury or may not be admissible before the jury. You know, as we've said before, there are many things we agree on. You know, Mr. Faust makes reference to several prior criminal convictions for attempted robbery, burglary, possession of a firearm by a convicted felon, and things along those lines over an extended period of time. And so those things, I don't think there's any argument from the state that those things are not going to be admissible before the jury, but I think that there may be some other things. I just want to make sure that we flesh that out before anything gets played before the jury.
All right, thank you. Ms. Cruz, anything you want to say in response?
No, ma'am.
All right. We will go ahead and do that. I think taking a longer lunch break, if necessary, is appropriate. I'll be downstairs. Y'all need to let me know if we need to take something up on the record before the jury gets back. All right. Anything else from the state?
Nothing else from the state, Judge.
Mr. Cruz, you ready for the jury?
I am, but I do have one matter. Your Honor, the WebEx link, is it possible that I could get that so I can start sending it out to witnesses? One is, I forgot the gentleman's name, but I spoke about him the first day his father died, as well as Ms. Keshana Armstrong, are two individuals that need the link.
And this is for your case in chief, is that correct?
That's correct.
Okay, so the easiest way to make that happen, because it is a very time-sensitive matter and it's hard if we are not in sync with the time that has been set to redo it. So as soon as we know when you're going to present your case in chief, I think is the best time to get those set up.
Yes, ma'am.
All right, but we will certainly do that.
Yes, ma'am.
All right, anything else?
No, ma'am.
All right, thank you. You can bring the jury in. Ladies and gentlemen, thank you again for returning here on time. We are ready to resume the trial, State of Georgia versus Edrick Faust, SU 24 CR 0547. Is the state ready to proceed?
State's ready, Judge.
Is the defense ready to proceed?
Yes, ma'am.
You may call your next witness, Mr. Yalamanchili.
State calls Bill Ricketts.
Could you get Bill Ricketts, please?
Sir, if you would, raise your right hand, take an oath. Do you swear or affirm the testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. If you would, please speak towards the microphone and just state and spell your name for the record.
William, W-I-L-L-I-A-M, Ricketts, R-I-C-K-E-T-T-S.
Sir, where are you currently employed?
I'm a supervisor with the Department of Homeland Security.
Okay. And what capacity do you, or is there a particular agency that you work with within the Department of Homeland Security?
Yes, sir. I'm a supervisor with the law enforcement section of the Transportation Security Administration.
Okay. Prior to working for TSA, were you involved in law enforcement in a different capacity?
Yes, sir. From 1992 to 1996, I worked at the Oconee County Sheriff's Office, and from 96 to 2001, I worked with the Athens-Clarke County Police Department.
Okay. And were you working with the Athens-Clarke County Police Department on January 19th of 2001?
Yes, sir, I was.
At that time, what was your assignment or role at ACCPD?
At that time, I was currently assigned with the Robbery Homicide Unit. I was in transitioning out into training at the time, but I was robbery homicide during that time.
Okay. And were you working on January 19th of 2001?
Yes, sir, I was.
All right. So I want to start kind of at the beginning of the day. Did your assignments at robbery homicide take you anywhere outside of Athens?
Yes, sir. That morning I was, I believe it was Milledgeville, Georgia. I was at the state penitentiary working a cold case homicide from, I believe, 1996. I spent the morning there and then drove back to Athens with one of the DA's investigators and came back to Athens that morning. I would say lunchtime or so, somewhere in that ballpark. Maybe.
Okay. And so just to clarify, though, this cold case homicide you were working from 1996, did that have anything to do with an individual named Ms. Tara Baker?
No.
Okay. And so when you got back, you said around lunchtime or so, was there anything unusual that you noticed when you got back to the police department?
Yes, sir. When we got back to the police department, pulled in the back where I normally park, and all of our vehicles and forensics and the CID units were gone, which I told the other investigator that wasn't a good sign for us for the day, and it was not. We went inside, and this is early in the days of cell phones, so we went inside, and I got assigned to go back out over to Fawn Drive.
Okay. And you said go back out over to Fawn Drive. Was that related to Miss Baker's murder?
Yes, sir, it was.
Okay. And what did you do when you arrived at Fawn Drive?
I arrived back on the scene and met with Lieutenant Durham. The crime scene folks were there. Talked it outside for just a few minutes with folks there. And then I began to talk to Lieutenant Durham, and he took me on a tour of the scene to get a look around so we could start taking some notes and look around. They had already been working for a pretty good bit of time before I got there. He showed me around the location, the crime scene. We looked at that. I took some notes. And then he kind of put me up to where he wanted me to go start doing some canvassing door to door and wanted me to do some other items that he had on his checkoff list that needed to be done.
So I want to start with your canvassing door to door. Did you speak to an individual by the name of Matt Owens?
Yes, sir.
Okay. And then did you also speak with an individual by the name of Tiffany Riker?
Yes, sir.
Okay. And so as it relates to Mr. Owens, what did he tell you about anything that he may have seen that day?
Objection, hearsay.
Any response to the objection, Mr. Yalamanchili?
Your Honor, I do believe Mr. Owens testified in this trial, and then Mr. Cruz challenged the credibility of certain things that Mr. Owens had said. So I believe that this would be admissible as a prior consistent statement.
I did not challenge the credibility of Mr. Owens. Mr. Owens testified. I don't even think I asked, well, not even think. I didn't ask Mr. Owens any questions. I just thanked him.
Right. Mr. Yalman-Chile, any response to Mr. Cruz's statement before I make a ruling?
Your Honor, if the defense is contending that he challenged nothing about the truthfulness and accuracy of Mr. Owens' statements, then I don't believe that the prior consistent statement would be admissible.
All right, I'm going to sustain the objection.
Thank you, Judge. Mr. Ricketts, so you spoke with Mr. Owens. We're not going to get into the details of what he said. Did you speak to an individual by the name of Tiffany Riker?
I did.
Okay. What is it that Miss Riker relayed to you?
Objection, Your Honor. Hearsay.
Any response to the objection, Mr. Yalman-Chile?
As it related to Mr. Owens, I don't have definitive memories of the ways in which Mr. Cruz may have asked questions or attempted to impeach that witness, but certainly as it related to Ms. Riker, there were significant periods of cross-examination, including confronting Ms. Riker with previous statements and things along those lines. So I do think that this would be admissible as a prior consistent statement.
Thank you. Yes, sir.
So my second objection based on the state's response would be waste of the jury's time. In regards to our examination of Ms. Riker, the only thing we went through were the statements that she gave to this officer. There was no need to impeach Ms. Riker on her prior statements because the testimony she gave in court, we used her prior statements from the day she spoke with Detective Ricketts to establish what her accurate testimony was.
All right, thank you, Mr. Cruz. I remember the statements, and I've taken notes on that. I'm going to overrule your objection and allow you to continue with that line of questioning.
So, Mr. Ricketts, as it relates to Ms. Riker, what did she relay to you?
She stated that morning around 8:15 in the morning she left to go to class. She saw a male subject, black man, walking down the street from the area of Cooper Road towards her apartment. Now, she said the male subject had to stop in order for her to back out of the driveway and go on. Her description, was a medium, average-looking height, medium, no hat, medium hair. It had an orange or bright red shirt, baggy pants, possible jeans, but they weren't dark in color. She gave us that description while we were sitting there talking to her. She was surprised that morning, and it was kind of a foggy, rainy morning that morning. I do remember driving down that morning. I wasn't at the scene during that, but that morning was a heavy fog, kind of rain kind of morning, kind of nasty. And she said it was kind of odd to have somebody cutting through just the apartment area at that time of morning.
And was the unusualness also based on the weather that she described?
She described the weather and then how the subject was almost walked into her car. It was one of those where if she hadn't seen him, she thinks maybe if she had seen him, they might would have run into each other, if that makes sense.
Okay. Did you conduct other canvas interviews?
I did.
Okay. And I'm not going to get into the details of those, but just talking about what you did that day. Eventually, did you end up back at the Athens-Clarke County Police Department?
Yes, sir. Lieutenant Durham sent me on several other assignments to take care of, and I did end up back at the police department later that afternoon.
Okay. While you were at the police department, and this would still be January 19th of 2001, is that correct?
Yes, sir, it would.
All right. So while you were at the police department, did you have any contact with an individual by the name of Chris Melton?
I did.
Okay. And who did you understand Mr. Melton to be at the time that you spoke with him?
I had understood Mr. Melton to be the boyfriend of the deceased. From being out at the scene, I had not yet seen or met him at this point, but I understood that's who he was.
Okay. And you said by being out at the scene, to your knowledge, had Mr. Melton been brought to the scene at some point during the investigation?
Yes, sir.
Okay. Do you know the purpose for which he was brought to the scene?
He identified the body, which I was told via digital camera from the crime scene, and was out on the crime scene answering some questions there, I believe, to Lieutenant Durham.
All right. Did you have an opportunity to speak with Mr. Melton?
Yes, I did.
Was there anybody else present when you were speaking with Mr. Melton?
Yes, sir. His father came with him. We weren't expecting him at the police department. He arrived, and he and his father were there together. So we decided to do an impromptu interview there at the office.
And where in the police department in particular did this interview take place, if you recall?
We were kind of over in that forensics area. We were not actually in an interview room. We were over in the forensics office. If you think of it, it's like a small conference room. I won't say a common work area, but a small conference room there where we could have a little bit of privacy and a table where we could sit and talk. The area was pretty busy that whole afternoon. We had several things going on at that same time, but that's where we decided to sit.
Okay. So what, if anything, did Mr. Melton tell you about his relationship with Ms. Baker?
So we sat and began to talk.
Your Honor, hearsay.
All right, Mr. Yelmanchili, any response to the objection?
Yes, Your Honor. I believe that Mr. Cruz attempted to impeach Mr. Melton regarding the, I guess, status or general place that his relationship with Ms. Baker was in at the time. And so I think that these would be prior consistent statements on that issue.
May I respond, Your Honor?
Of course.
During our cross-examination of Mr. Melton yesterday, the exact statement he gave Detective Ricketts about his status, Mr. Melton testified to. My concern, Your Honor, as we just saw with Ms. Tiffany Riker, is the state is attempting to use this officer to change the testimonies of other witnesses. That's why we're raising our hearsay objections. Ms. Riker has testified, Mr. Melton has testified. If it truly is a prior consistent statement that was not elicited or left hanging, which it would lead to a misinterpretation, yes, he could bring it up. But just to ask this officer to follow up and give the same testimony that that the actual witnesses have come in and give themselves, I ask that the Honorable Court, sustain our hearsay objection in that regard.
All right, thank you. Anything further before I make a ruling?
Just briefly, Your Honor, the prior consistent statement rule for admission has to do with exactly the situation Mr. Cruz just described, as far as a witness having testified, the defense attempting to impeach that witness, and then later that witness's prior consistent statements from the time coming in to show that that impeachment isn't credible. So it's the very purpose of the rule.
Yes, sir. Yes, sir.
I disagree with that, Your Honor. Prior consistent statement is if I challenge the credibility of this witness on that statement, and then the state comes in and say, hey, he's elicited testimony that the witness has said one thing, but we have a consistent statement from the past showing that his testimony in court is consistent with the statement that he's made before. We don't have that issue here because Mr. Melton, the same testimony that Detective Ricketts can give to the Honorable Court, Mr. Melton gave. And I can say the statement I won't because I don't want to put any, I don't want to taint the witness. But I would just ask that if there are prior consistent statements that the state would like to use, that's fine. I won't object to those. But just to ask Detective Ricketts what other witnesses told him, we would ask the Honorable Court to sustain our hearsay objection on that ground. All
right, thank you. I think it's the first time in this trial you both are right. You're both correct about what a prior consistent statement is. I am going to sustain and overrule the objection. I'm going to do both. And so this is what I'm going to limit the state to. With regard to the statements that you are seeking to elicit, they need to be connected to the issue of impeachment and any necessity for a prior consistent statement. It cannot be, for example, as Mr. Cruz has just outlined, an entire narrative of the interview with Mr. Melton. So I'm going to ask you to limit your questioning. I'm going to make a ruling that you have to limit your questioning of this witness to the specific areas that you're seeking and arguing need a prior consistent statement.
Yes, Your Honor.
All right.
And so I will not ask the witness, what did he tell you? I will try to be direct, which should give Mr. Cruz an opportunity, if he has additional objections, to bring them up at that time.
That's correct.
All right.
May I proceed?
So, Mr. Ricketts, I want to ask you very specifically, what is it that Mr. Melton told you about the condition or status of his relationship with Ms. Baker at that time?
That is hearsay without exception. I would object.
All right. Mr. Yelmanchili, any response to the objection?
I was just restating the previous question I'd asked, and I think it is directed in the manner that the court informed or instructed me to ask it in order to be admissible as a prior consistent statement exception to the hearsay rule.
I'm going to overrule the objection. You may continue.
And so, Mr. Ricketts, I'll ask you the question again. What is it on January 19th of 2001 that Mr. Melton told you about the condition or status of his relationship with Miss Baker?
He said they had a serious relationship and had talked and had intentions of marriage in the future.
Okay. And then, I want to take you forward a little bit. We've talked about the general nature and status of their relationship at the time. What, if anything, did he tell you about the plans that he and Miss Baker had for that weekend?
Objection, Your Honor. Hearsay.
Mr. Yalamachili, any response to the objection?
Your Honor, again, it is a prior consistent statement. Mr. Cruz, in his cross-examination of Mr. Melton, indicated that at the time leading up to Miss Baker's murder, the two of them may not have even been in a relationship. He referred to Miss Baker as his girlfriend or ex-girlfriend. So prior consistent statements regarding the fact that they were in a relationship and had plans together that weekend that both were excited about would be a prior consistent statement that would be admissible.
Ms. Cruz, anything further, sir?
Sure. Mr. Yalamachili's purpose for admitting this isn't because Mr. Melton or I elicited inconsistent testimony or inconsistent statement. It's the statement that matters, not the general view, not the general theory of the witness, the statement. We did not get into, on cross-examination, Mr. Melton's plans with Ms. Baker on the weekend after her death or the weekend following her death. We spoke about the relationship generally. So I would ask the Honorable Court to sustain the hearsay objection.
All right. Yes, sir.
And I would just add, Your Honor, the state had opportunity to examine Mr. Melton on direct and redirect examination. I do think it's inappropriate to now try to bolster or support Mr. Melton's testimony through Detective Ricketts, as the jury has had opportunity to hear from Mr. Melton themselves.
All right. Thank you, Mr. Cruz. I'm making a finding that the very issue that the state is asking to have this witness speak about, which is the weekend after the incident, was in fact brought out on cross-examination. The articulation the state has made about what a prior consistent statement is with regard to that issue is accurate, and I'm going to allow you to do it. I'm going to overrule the objection.
So, Mr. Ricketts, I'll ask you again, and I'm trying to make this a specific, tailored question. What, if anything, did Mr. Melton tell you about plans that he may have had and Ms. Baker had for that weekend?
Yes, he went in depth about Tara had plans that evening with friends and family for a birthday party on the 19th for that night, and that he had planned something for her on Saturday night where they were going to meet and be together that evening on the Saturday the 20th.
Did he express anything to you about their feelings regarding those plans?
Yes, on the Friday, numerous times when we were talking, he said that Tara wanted him to drive down and be there for the 19th for the party at the winery with folks from the law school and from the law firm where she worked. He didn't think scheduling-wise.
Objection. I am so sorry, Your Honor.
Okay.
This testimony is an accurate testimony from anywhere in this file. The disadvantage that Mr. Faust has right now when they are bringing in another witness to testify regarding what Mr. Melton may or may not have said, we have no way to cross-examine Mr. Melton on that information. I would ask that the state ask Detective Ricketts questions related to Detective Ricketts' personal knowledge, not information he's heard from someone else, unless it falls under his exception, of course. But to the last question, to the answer, Your Honor, our objection is hearsay.
All right. Thank you, Mr. Cruz. Mr. Yalamachili, I know the witness is in the middle of a statement, but go ahead.
Your Honor, I think it's the same argument that the court just ruled on, a minute ago, that this is admissible as a prior consistent statement. And I believe it falls within that exception to the hearsay rule, as the court's already indicated.
Mr. Cruz, let me just ask you a question so I understand your objection. Are you arguing that this information was not elicited when Mr. Melton was on the stand?
I am arguing that the statement that was just made from Detective Ricketts doesn't exist in the case file. So I'm not saying this is intentional.
I'll let you respond in just a moment, Mr. Cruz.
I'm not saying this is intentional from the state. I don't think it's intentional. But what's going on here is Mr. Melton testified yesterday. I'm assuming the state didn't get the information that they would have liked Mr. Melton to say, so they brought in Detective Ricketts to now become a surrogate of Chris Melton, and they'll ask Detective Ricketts, well, what did Chris Melton say about this? What did Chris Melton say about that?
Okay, hang on just a moment. Ladies and gentlemen, I want to take this up outside your presence, all right? So if you'll go into the jury room and don't talk about the case, I'll be with you shortly. Thank you. I wanted to do that in the event, Mr. Cruz, you were talking about things that were not elicited during testimony. I didn't want the jury to hear it if that, in fact, was the case. You may continue your argument. Go ahead.
But my concern is, Your Honor, is the state is attempting to circumvent the rules of evidence by using Detective Ricketts to elicit testimony that, of course, during cross-examination, there's no way I can impeach Detective Ricketts on things that Chris Melton said while Detective Ricketts is on the stand.
I want to make sure I understand your objection, Mr. Cruz. Are you arguing that what Detective Ricketts is talking about right now or about to talk about was not brought up when Mr. Melton was on the stand?
Well, my objection is hearsay.
No, I understand that, but are you also saying that it was not brought up, that that particular information was not brought up when he was on the stand, or something different?
Generally, yes, but this wouldn't fall under a prior consistent statement. I didn't get into plans for the weekend. Our entire theory of cross-examination with Mr. Melton was the deterioration of the relationship before her death. The statements, if they wanted these statements from Mr. Melton, they could have talked to Mr. Melton about them. These were, and we could have gotten into it on cross-examination with Mr. Melton. These were outside of the statement that was just made. But as far as Mr. Melton stating, hey, she wanted to see me, we had plans for Saturday, those are accurate statements. As far as, oh, she wanted me to come that night, and we had all this stuff laid out, that's not anywhere in this discovery packet. We looked through all 25,000 pages and 25,000 files. That is not in here. But it would be inappropriate to cross-examine, and let me put it this way. Mr. Faust has the right of confrontation. Mr. Faust has the right to cross-examine statements of witnesses. The state is attempting to use Mr. Ricketts as a surrogate for...
I understand exactly what you're saying, but I want to get I need to understand very specifically what you're arguing. I understand what you're saying about this witness testifying about what other people said, and you're not having the right to confront the actual declarant. I understand that. What I need to know, Mr. Cruz, is what exactly are you alleging does not fall under the exception for prior consistent statements? So you've made two statements. I just want to make sure I understand what you're saying. You are saying, number one, that the information this witness is providing was not in the discovery. And certainly that's one thing. But in terms of this objection, are you also saying that Mr. Melton did not provide it on the witness stand, that this is something you've never heard or something different? That's what I don't understand what you're saying.
Please forgive me for not being...
I mean, that's okay. I just want to make sure I understand what you're saying.
So our specific position is that this is hearsay that does not fall under the prior consistent statement rule. And the reason why we did not elicit a statement from Mr. Melton that was inconsistent with anything they had, I'm going to say allegedly, had planned on Friday or Saturday. My cross-examination didn't even delve into plans because our position, as the Honorable Court is aware, is that they weren't together. So we didn't get into that, we did not get into those statements with Chris Melton. If the state would have liked to get into that with Chris Melton, they could have did it during redirect or direct examination. But
I understand what you're telling me now.
Yes, ma'am.
All right, thank you very much. Mr. Yalamachill, you care to respond?
Yes, I
Go ahead.
think Mr. Cruz, in part, just made the state's argument for us. He has just said that the entire contention during his cross-examination is that these parties may not have been in a relationship. Mr. Melton did, in fact, testify that he and Miss Baker had plans for that weekend that he and Miss Baker were excited about. And then on cross-examination, Mr. Cruz tried to develop a theory that the two of them were not in a relationship. And so that is obviously a challenge to Mr. Melton's testimony that they were in fact in a relationship and had plans that they were both excited about this weekend, as Mr. Cruz has just indicated was the purpose of the cross-examination questions that he asked. So I do think that this evidence is admissible. I would also like to read to the court from Detective Ricketts' narrative talking about the things that Mr. Cruz has been alleging are not in the discovery. Chris told me that Tara was excited about Friday night. It was her birthday, and she was going out with her girlfriends. Chris was going to take her out the next night, which was exactly what Mr. Ricketts was just in the process of testifying to, Your Honor. So, I mean, I understand why the defense doesn't want Mr. Melton's prior consistent statements to come in, because they cast doubt on the impeachment mechanisms that the defense has attempted in this trial. However, that is the entire reason that a prior consistent statement may be admissible in the trial of a case when the defense or the state, depending on who called the witness, has impeached or attempted to impeach that witness, Judge. So, I mean, I think it's a textbook example of when a prior consistent statement would be admissible.
All right, thank you. Yes, sir.
Can I just say this, Your Honor? I'll leave
Right.
it to the Honorable Court's discretion.
Thank you. I'm going to relook at the law. I'll be with you both shortly.
To subsection C of 24-6-613, and it will be the second sentence that would.
I've got it, Mr. Cruz. Thank you.
Yes, ma'am.
Going to overrule the objection because this is the law. A prior just so we're clear. A prior consistent statement shall be admissible to rehabilitate a witness if the prior consistent statement logically rebuts an attack made on the witness's credibility. A general attack on a witness's credibility with evidence offered under Code Section 608 or 609, which is not the case here, shall not permit rehabilitation under this subsection, but we're clear that does not apply. If a prior consistent statement is offered to rebut an express or implied charge against the witness of recent fabrication or improper influence or motive, the prior consistent statement shall have been made before the alleged recent fabrication or improper influence or motive arose. I'm going to overrule the objection. You may continue, Mr. Yalomashili. You may bring the jury in. Thank you,
Judge.
In the restroom? Okay. At ease. We have a restroom moment.
as to the witness whether or not he would like a glass of
Of
water?
course.
He got me one. Thank you very much, sir.
Okay.
The ruling that I just made needs to be consistent with the prior ruling that I made when I sustained Mr. Cruz's objection. This questions about questions that the state feels support prior consistent statements cannot be a narrative, just in general. It has to be specifically tailored to the moment in question that the state feels is entitled to be rehabilitated. All right, thank you. You may bring the jury in. You all may be seated. Thank you. Gentleman Chile, you may proceed.
Thank you, Your Honor. Mr. Ricketts, before we took that brief break, I had asked you a question, and I'm going to try to, as best I can recall, ask you the same question again. Did Mr. Melton talk to you at all or say anything to you about plans that he and Ms. Baker had for that weekend and their feelings surrounding those plans?
Yes. He advised that Tara was very excited about her birthday coming up the weekend, and that she and friends from law school and the law firm she worked at were all getting together at the winery on Friday night, and that Chris had made plans on Saturday the 20th to meet and take her out to celebrate her birthday.
All right. And as it relates to Mr. Melton's whereabouts on Friday morning, January 19th of 2001, is that something that y'all discussed in your interview?
Yes. One of the reasons Friday night that he wasn't going to be down is for work on Friday. The new area where he was working and things of that nature was taking time away. He had jobs to do on that Friday, so he said Saturday would be a much easier thing. And she had her college law school friends and her law firm friends and all to do the dinner with on Friday night.
Okay. Well, and so my question, I might not have been clear in it, and I apologize for that, is did he talk to you about where he was Friday morning?
Yes, he did.
Okay. And what did he tell you about that?
He spent the night and had spent most of the nights that week with his mom and dad, and it was at their residence. I have the address here if you need it, but he was at their residence that night until he went to work that next morning.
Okay, and I don't think we want to or need to say any specific addresses, but when you say until he went to work that morning, did he talk to you about when that was and where he went on that morning of January 19th of 2001?
Yes, sir. He laid that morning out for me. So his morning was to have his helper, his friend Chris, show up to help him that morning at the house there between 7:15 and 7:30, and then they left to start their day.
Okay. Did he talk to you about where they went when they left to start their day?
Yes, sir. His first, on this encounter on the 19th, they stopped at Nash Plumbing first off to load up with gear and equipment for that day, for the projects and the jobs that they were going out to do. He said they loaded up to there, and then they were headed over to try to make a stop over at Truck Customs. Chris explained in the interview that he was trying to get a ladder rack put on his truck. They needed to measure it, and then he would go back later in the day and they would install that ladder rack, was my understanding of the conversation we were having. That location is in Loganville, Georgia, and he went there in order to get that measured out. They left there and went over toward Grayson, Georgia, in order to do a job there, check for some leaks, that kind of thing at that house. From there, they went on to Forsyth, met up with a contractor there to look at doing a house there in Forsyth. Now, the house there, I guess it wouldn't have it had boarding on it, but no paper and shingles, I guess, if that makes sense. And I think they were just getting pretty wet. They were going to lay the house out to do the initial plumb of the residence that day. but there was no cover on the roof, so they were kind of getting wet. So Chris stated he went back by Truck Customs just to stop in and see if maybe they happened to be ready on his way back to his house. And when he went back to the house, he just dropped Chris off.
Narrative.
All right, any response to the objection?
Your Honor, I mean, I think it's all still responsive to the initial question of what Mr. Melton relayed to him about what he was doing and where he went that morning.
I am going to sustain the objection. I do think it is a narrative. I'm going to ask the questioner to walk their witness through appropriately.
Yes, Your Honor. Thank you. Mr. Ricketts did, so we're at Truck Customs at this point. Did Mr. Melton tell you where, if anywhere, they went from Truck Customs?
Due to the weather and whatever else, he went back to the residence, dropped his helper off in order to let him go eat and see if they could maybe wait the rain out and see kind of how that would go. He advised that they would meet up together later and try to complete some more work or go back by Truck Customs.
And I'm sorry, let me just ask you some questions as we go along here. You just testified that he had dropped his helper. What was that person's name?
Chris.
Well, Chris Melton's
Oh, I'm sorry.
helpers.
I have to look back. I apologize.
That's all right.
Give me 1 second. I'm so sorry.
Objection, Your Honor. I object on the grounds of hearsay to the witness having his notes while he testifies. If the state would like to refresh the witness's recollection, there's an appropriate mechanism to do that. But for the witness to be able to use his notes while he testifies, that constitutes hearsay.
All right, thank you. Anything from the state before I make a ruling?
I think that's correct. We can go through asking those couple of questions if the court would like.
All right, very good. I'm going to sustain the objection with regard to how to refresh a witness's recollection, but I'm going to overrule the objection with regard to having the report on the stand. A witness is entitled to have it on the stand. They just have to use it appropriately. You may continue.
And so, Mr. Ricketts, before you refer to your report, please, indicate to me that you may need to do that, and we'll go through the appropriate questions.
I understand.
My understanding from your last answer is at this time you can't necessarily recall the name of Mr. Melton's helper. Is that correct?
Yes, sir.
All right. Do you think referring to your report would help you refresh your recollection?
It would.
Okay. Please refer to the report. Do not read from it, and just let me know when you've had a chance to review it.
Yes, sir. His first name is Josh.
Okay. So I think, do you recall now, after having reviewed your report, that individual's name?
Yes, Josh McCurdy.
Yes, sir. Okay. So you had just testified that Mr. Melton dropped Mr. McCurdy off at Mr. McCurdy's residence. Is that right?
They were back at Chris's house. They needed both the vehicles, from my understanding, because Josh went there. But when they went back to Truck Customs, Josh, he was going to have to follow him back to Truck Customs. In order to leave Chris's truck there, they would need the second vehicle. So he went to lunch at that time.
Okay. Did they ever return to Truck Customs?
Yes, sir.
All right. And what did Mr. Melton, what did Mr. Melton tell you about where he went after he left Truck Customs?
He went to Truck Customs, he said around 3:45, 4 o'clock for an appointment that he had there. And he got a page that he received while he was there. He received that page, made a phone call, and then went to Athens to the address on Fawn Drive.
Okay. And when you say the address on Fawn Drive, are we talking about Miss Baker's residence where she was killed?
Yes, sir.
Okay. During this interview, this is January 19th of 2001, did you have an opportunity to observe Mr. Melton's hands?
I did.
Okay. What did you observe about Mr. Melton's hands?
During the interview, while we sat and talked, Mr. Melton for lack of better words, just picked at his hands and messed with his hands, pretty much just moving glue and things off his fingers from his fingernail beds and just kind of making that kind of movement while he was moving with his hands. You could see that. And then I had the opportunity to fingerprint him for prints. And at that time, we didn't use computers like we do now. We had to do manual prints, ink prints. So I printed him both hands on the printing, pretty much with a desk just like this. Start with outside and work to inside. So I had to hold and sit and stay there and hold his hands and roll each finger out as I made the fingerprints. And then I would move over to the other hand and do the same exact thing and work through all 5. So all of his fingerprints were done there at the police department after we finished this interview.
And you yourself did that rolling of the prints? Is that what you just testified to?
I did.
Okay. And I just want to go through that process again a little more slowly. Did you just testify that all 10 of his fingers would have been printed? Is
Yes,
that
sir.
correct? Okay. And when you're going through that process, do you make contact with the person you're printing?
Sure. So unlike now, you have to take your hand and you hold the print, the finger, you go to the far side and you roll it because you're getting ink. So now with a computer, you can sit and look at a screen and kind of move it around. But with this, you had to dip his hand in ink. You take it and roll from side to side, and then you would move one at a time from finger to finger. So I dip, roll, dip, and roll, and then get the thumb, and then you move around to the other side. And each time you do that, you have to grab the hand, and you have to hold the hand and do it. And they have to kind of hold their hand real loose and kind of give you kind of control of the hand. It's a much better system we have now. But at that time, I had to sit and hold his hand during that time while we were doing that.
All right. And so I want to fast forward a couple of days and then rewind back a couple of days. Did you have an interaction with Chris Melton on January 21st of 2001?
Yes, sir, I did.
Okay. And during that interaction, did you and Detective Newton take any pictures?
Yes, we did. We took pictures.
Okay. In particular, on Mr. Melton's hands, when y'all met with him on January 21st, was there anything that caused you to take pictures of his hands?
Yes, he had marks on his hand on Sunday that weren't there on Friday evening when we talked to him. And so when we were taking pictures, we took pictures of those also in the rest of his body.
So when you met with him on January 21st and you saw the marks, you took pictures of those, or Detective Newton, y'all took pictures of those?
Yes, on the 21st, we saw those. We did the other stuff we had to do, and we also took those pictures.
Were those marks on his hands on January 19th of 2001 when you interviewed him and then fingerprinted him?
They were not.
Okay. If they had been, would you have taken pictures of them the way you did on January 21st?
Yes.
Okay. And this is a little bit of an aside. Have you ever worked with plumber's glue and some things related to plumbing?
Sure. So there's primer and there's glue, and you know the glue gets all over your hands. You have to peel it off, things of that nature. On the interview on Friday, I was just watching individuals we were interviewing, and he was picking at his hands. One, I think, for concentration and trying to cope, if that's a word. I don't know, but he was just trying to pick at his hands and pull that glue off. None of the stuff that I had to do, like if your hands are extremely dirty, like if I got somebody on the street, I needed to print them, I'd have to clean their hands in order to take prints. So there was nothing on his hands that impeded with me taking fingerprints. So I didn't have to go scrub his hands, which I've had to do before, where we've had to get somebody and scrub their hands in order to get prints. We didn't have to do that. Glue primer is usually purple, and I won't say it's see-through, but it's not. It doesn't block, and glue doesn't either. It just peels up, and you have to peel it off.
So, well, and let me ask you this question then. Was there anything about the things on Mr. Melton's hands on January 19th of 2001 that would have prevented you from seeing these injuries if they had been there?
No, there was nothing covering his whole. From the picture, you would have had to cover his hand from about where my shirt stops all the way to his fingertips to cover that up, and his thumbs and that area right in there. So you would have had to cover everything.
Okay.
And the plumber's primer and the glue, it gets on your skin, but it's not that bad. I plumbed the house when I built my house. I'm not very good at it, but I got more stuff. But you can see through it. Like if you cut yourself or anything like that, you're going to see that.
Okay. So I want to go forward to January 20th of 2001. So this is the day between the first day in time that you ever talked to Mr. Melton and the second day in time that you talked to Mr. Melton. Did you take any investigative actions in order to, I guess, see if you could talk to some of the people that Mr. Melton had mentioned to you about being with him or around him on Friday morning?
Yes, we made phone interviews on Saturday from the police department.
Okay. As specifically as it related to Mr. Melton's whereabouts on January 19th, who did you talk to on January 20th?
I talked to Josh, and I also talked to Mr. Teeters.
Okay. And you've already testified about who you understood Josh to be. Who did you understand Mr. Teeter to be?
From Truck Customs.
Okay. And is that the Truck Customs that you were making reference to?
Yes, sir.
Judge, I'm going to turn the Elmo off, or can the court turn it off? I just don't want to put something down here inadvertently and have it displayed, because I almost did. Thank you. Okay. Well, and so as it relates to Josh McCurdy, what did Mr. McCurdy tell you about his whereabouts and Mr. Melton's whereabouts on January 19th of 2001?
He drove to Chris's house that morning, approximately 7:15. He said to 7:30, and he said their first stop was at the plumbing. They went there first. If I could refer to my notes, I can tell you that he also mentioned that they went by a Chick-fil-A that morning also.
Do you, and so as you sit here, are you having difficulty recalling the remainder of what Mr. McCurdy told you?
Yes, sir.
Do you believe that reviewing your report would help refresh your recollection?
Yes, sir.
Okay. Would you please do so? Then don't read from your report, but let me know when you finish reviewing.
Yes, sir. So he does mention that they went by Chick-fil-A that morning also for some breakfast.
Did Mr. McCurdy tell you anything about where they went after Chick-fil-A?
To Grayson, which is just right down the road from.
And was there a particular time he said he believed that they had gone to Grayson?
He thought it was between 8 and 8:15.
Okay. And from there, did he tell you anywhere that they may have gone after that?
He mentioned Forsyth and the place with the rain, and he was talking about just how wet they were getting and weren't able to get in and out from underneath that rain. He said that it was just too much rain to get any work done there.
Okay. And so after they left Forsyth, did Mr. McCurdy say anything about where they went next?
He did mention they went back to Truck Customs that afternoon.
Okay. Did they go anywhere between Forsyth and Truck Customs?
They did stop for lunch, for the lunch break that they mentioned earlier, if I didn't mention that.
Okay. And then did Mr. McCurdy say anything about anything that happened while they were at Truck Customs in the afternoon?
He mentioned the page in detail, and then he talked about how they left Chris's truck there and he drove him to Athens. He didn't want Chris to have to make that drive, but he drove them all the way to Athens.
Did he say anything about any fears that Mr. Melton had or any actions that Mr. Melton took as they drove to Athens?
No, he said that while they were in the truck that Chris was calling information, trying to track down other parents of the girls there and trying to make contact as he drove from that area. I'll just say Loganville because it's the easiest there, but as they drove down from Loganville to Athens, he was trying to get information and see if he could make contact with family members.
Okay. And did he say anything to you about any types of worries or fears that Mr. Melton had?
Objection, Your Honor. Hearsay.
Any response to the objection?
Judge, under 24-8-8035, past recollection recorded, I believe yesterday during Mr. McCurdy's testimony, the foundation for that was laid, and this would be that past recollection recorded, being admitted under exception to the hearsay rule of 24-8-8035.
All right. Mr. Cruz.
Your Honor, I'm pulling up the law. Okay, so 8035 does not apply in this case. The state, if they wanted to use past recorded recollection, it's not Detective Ricketts who they would use it with. It was Josh McCourty who they could use it with. I'm becoming concerned that the state is trying to use Ricketts to override everybody else's testimony. So I would just ask the Honorable Court to instruct the state not to elicit hearsay. If it's something that's a personal observation of Detective Ricketts, that's lawful, that's legal. As far as just going through witnesses and saying, hey, what do they say about this, what do they say about that, I believe that is improper.
Okay. But your objection is hearsay.
It is.
I'm going to sustain the objection.
And okay, so I'm going to move forward then, Detective Ricketts, and talk to you. You've already mentioned that you had a conversation with Mr. Teeter, is that right?
That's correct.
Okay. I don't think we need to get into the contents of that conversation, but I do want to go forward with you to January 21st of 2001. Did you have contact with Mr. Melton again on that day?
I did. He voluntarily came back and met with us.
Okay. When Mr. Melton met with you, did he have anybody else present with him?
His family was with him, but they came back with him, but his dad was with him.
Okay. When you spoke with him, and I think you already mentioned taking photographs of him, who all was present when that was happening?
Just Chris and Detective Newton and myself.
Okay. And did Mr. Melton give you any additional information beyond what he told you on Friday evening about where he was on Friday morning?
We went back over the timeline of events from Friday, and Chris added that he had stopped by the Wachovia Bank in Loganville just after 9, which he didn't mention on Friday, which we took note of that. And then on Monday, some other detectives went to run that to ground. That information wasn't passed on a Friday, but Chris talked about it with me on Sunday. Everything else pretty much stayed the same except for that.
All right. And so when he was meeting with y'all on January 21st, did anything come up regarding a blood sample?
Yes, toward the end of our conversation at the police department, we talked about the crime scene, things of that nature. It's the first time that I brought up with Chris that there was the possibility that Tara had been sexually assaulted. We had a brief conversation about DNA and some things of that nature, and I told him that at some point we would need to get consent and he would need to do a sample for us, and he agreed. So a warrant wasn't necessary, but he agreed to go with us to Athens Regional or Piedmont Hospital to do that.
Did you attend or observe that blood draw?
I did. We went there. They followed us over. We had made contact because it was a Sunday, and we had a nurse in the lab do that for us. And I observed both vials be drawn, placed in the evidence bag, and then I took them back to the police department and placed them into evidence.
Did Mr. Melton make any statements to you about the last time he and Tara had sex?
He did. From going over my notes and listening to the recordings, I can't give you a precise date. His voice trails off there, but it was in that week period of time, sometime between that last weekend. I want to say it was Saturday or Sunday would be my best recollection. The recording goes off, kind of, that microcassette recorder's not real good.
Sorry.
That's okay, sorry, sir.
Off there. Let's talk about the tools that you had in 2001. Obviously, nowadays, we all walk around with these guys that have a recording function on them. When you were a police officer in January of 2001 and you needed to record an interview with an individual, what equipment were you provided with in order to do that?
We were using microcassette recorders. Audio wasn't always the best, but we did pretty good on it. You can listen to them. It's pretty hard to. We used those. I laughed talking to some of the officers waiting for grand jury this morning. They didn't understand it. This was the first area of time when we were doing these reports in 01 that was word processing. So if that makes sense, we had done everything else before that on typewriters. So word processing was kind of new, and we were using microcassette recorders, which weren't the great. Athens Clarke County at that time was in the process of putting up interview rooms with video cameras and things of that nature, but they weren't. That was not the norm.
So, I mean, is it fair to say that this was a period of time when, like, the use of technology and the tools that y'all had available was in a period of transition?
Huge.
Yeah. So, as you were there on January 21st, I want to go and retrieve some things from evidence and show them to you. So, if you bear with me for just a moment. Okay. Two exhibits. They're both admitted into evidence already. They're defendants exhibits 29, and then, I'm sorry, I said two exhibits, two sets of pictures. So D29 has been marked collectively, so all the pictures are D29. And then I'm also going to hand you defendants exhibit 37, 38, 39, and 40 that have been admitted into evidence already as well. Hand those up to you. I'm going to give you a chance first to look through them, and then if you just let me know when you've had a chance to look through them, I'll continue asking you questions at that point.
Okay.
Detective Ricketts, in the collectively marked exhibit that I handed to you, where there's one number but a bunch of pictures, do you recognize those pictures?
This one right here?
Yes, sir.
Yes, sir, I do. These were taken at Piedmont, Athens Regional.
Okay. And again, who was present when those pictures were taken?
Detective Newton, that's his arm right there in the picture right there. He took these photos here, and I took the other photos.
Okay. And those images the injuries that are depicted on those hands, were those present on January 19th of 2001 when you interviewed Mr. Melton and then fingerprinted them?
They were not.
Okay. And then the other set of pictures that I handed you, I want to ask you a few questions before we talk about those. I think they're defendants exhibits 37 through 40, if I'm recalling correctly.
Yes, sir.
Okay. When you noticed those injuries to Mr. Melton's hands, was there any explanation provided by him for where those injuries came from?
I talked to him about those. He advised that when he got back to his apartment that went in was alone for a period of time, that he kind of lost it. He said as soon as he walked in the door, it was there on the right side when you go into his apartment, and he just punched the wall numerous times. And then he said he sat on the floor and just cried.
Did you ever go to Mr. Melton's apartment after you talked with him about those injuries and how he received them?
So I believe it's the 23rd. Went over. I believe that's the correct date. But yes, sir, I went and I took these photos in the apartment.
Okay. And when you say these photos, are you referring to defendants exhibits 37 through 40?
I am.
Okay. The damage that you saw to the wall, was that consistent to you with the injuries that you saw on Mr. Melton's hands?
It is.
Okay. Detective Riggets, thank you so much for your time. I don't have any other questions for you right now, but I'm sure Mr. Cruz may have some.
Yes, sir.
Cross-examination, Mr. Cruz.
Before our cross, may I use the bathroom?
Yes. Why don't we take a 10-minute recess and allow everybody to use the restroom? We'll be off the record until about 10:25. Thank you. Don't discuss the case. We'll see you all shortly. back on the record. You may bring the jury in. Thank you. You all may be seated. Mr. Cruz, cross-examination.
Good morning, Detective Ricketts.
Hey, good morning.
My name is Attorney Ahmad Cruz, and I have the privilege and honor of representing Mr. Faust. Under the authority of this honorable court, I'm going to ask you some questions. Is that okay?
Yes, sir.
Okay, excellent. Detective Ricketts, you were with ACCPD, is that correct?
That's correct.
Okay, and during the time of this investigation, you were with ACCPD, is that right? Would you agree that ACCPD dropped the ball on this investigation?
No.
Okay. You believe ACCPD followed up on all leads,
Yes.
confirmed all information?
I think so. I would like to add something to that if you would allow me to.
I can't answer any questions. We could talk about it after, though, if that's okay. This time,
No, I think I'll answer that question. Yes, I wish if you look back at any case 25 years ago and look at it with fresh eyes from 25 years ago, yes, things would have been done totally different, I think, with some options and things that would have happened. Everything that I can say to, and I will not answer on behalf of ACCPD, but on the days that I was a part of this case, I will say, I think, yes, we did. But I think if you look at anything 25 years back, I think if you look at something I did last week, there'd be things that I would like to improve on. Okay. But I don't think drop the ball would be a word I would ever use.
Sure. Do you believe ACCPD followed the evidence appropriately?
Yes, sir. The evidence, to my knowledge, I believe they did.
Okay. And I'm assuming that you met with the prosecution before you testified today. Is that right?
That's correct.
Okay. Do you or ACCPD feel a need to justify why Chris Melton was not arrested?
No.
Do you or ACCPD feel the need to have to defend Chris Melton?
I don't believe I'm here defending Chris Melton.
Sure. So that is a yes or no question.
Then please repeat it.
Yes, sir. Do you or ACCPD feel the need to defend Chris Melton?
No.
Okay. Do you or ACCPD feel the need to defend the state's case?
No.
Okay. So I'd like to ask you some questions about a couple of things that you talked about on direct examination, okay?
Okay.
For starters, would you have any reason to disagree that January 19th, 2001 was 9,153 days ago?
Sounds appropriate.
Okay. And I'm going to use this whiteboard over here.
Yes, sir.
So 9,153 days since 1/19/01. Fair?
Sounds correct.
In 2001, can you tell us what team won the Super Bowl?
I cannot.
Okay. In 2001, can you tell us what team won the World Series?
No.
In 2001, can you tell us what your favorite song was?
No.
Okay. So no to Super Bowl, and forgive my handwriting. It is terrible. No 2 World Series. Know the favorite song. My handwriting's terrible. And this is know the favorite song. Correct. And you would agree that your notes say nothing about Mr. Melton picking anything off of his hands. Is that correct?
No, sir. I'm going with that from the recollection of the audio cassette tapes from that day.
So your statement to this jury is that based on the audio cassette of that day, it refreshed your recollection that Mr. Melton was picking items off of his hands.
Yes, sir. You asked me about the Super Bowl. Not an NFL guy, not a baseball guy.
That's fine.
The crime scene for Tara Baker, I'll never forget.
Mr. Ricketts, that's a yes or no question.
Well, repeat your question, please.
Witness is allowed to explain his answer.
May I be heard on that, Your Honor?
You may be, yes.
I would disagree with that. The witness on cross-examination, my job is to posit to the witness yes or no questions. If the state wants the witness to elicit further testimony, they do that on redirect. At this time, Your Honor, I pretty much give the witness what the answer is. They can answer yes or no, and we decide which direction we go from there. So I would ask that the witness is not allowed to control cross-examination, to control Mr. Faust's rights to cross-examination, and we're allowed to ask the witness leading questions that the witness answers appropriately.
Okay, so this is not about witness control. This is about what the law allows. And cross-examination questions are yes or no questions, certainly. But the law allows a witness to answer yes or no and then explain if he or she chooses to make an explanation. And so I'm going to overrule your objection. He is allowed to explain if he chooses to. If there are further objections the court needs to make with regard to those explanations, I certainly will hear it.
Yes, ma'am.
If you'll ask the question again, Mr. Cruz. Thank you.
Sure. And I withdraw that question, Your Honor. I withdraw that question. But my understanding is the audio is what refreshed your recollection in regards to what was on Mr. Melton's hands.
Yes.
Okay. And that audio is from January 19, 2001.
That's correct.
Okay. And you've already listened to that audio because the state provided you with a copy. Is that correct?
Yes, sir.
Okay. And if you were to hear that audio, you would recognize it. Is that fair to say?
Yes.
Okay. Court's indulgence. Turn the volume down on this. I'm going to move the mic out the way.
Okay.
I'm going to allow you to hear the audio. I want you to listen to it. When you feel comfortable that you recognize the audio, just look up, okay? Is that fair? Is that fair?
Yes, sir.
May I approach the witness, Your Honor?
You may.
Yeah. Sounds like something is playing. Give me 1 second. And here you go. And if you need to turn it up just a little, you can press that button right there.
You can turn it up if you need to. Correct. If you recognize it, if it's accurate, what you recognize it as.
This sounds like the beginning of the audio from the 19th.
Correct. With you and Mr. Chris Melton?
Yes, sir. His father.
Okay, that is fair. Does that sound like a fair and accurate rendition of that recording as you remember it? Now, what I'd like you to do, I'm going to mark that flash drive, which has been identified by the witness as the interview between Detective Ricketts and Chris Melton on January 19th, 2001, as Defense Exhibit 44. Let the record reflect that I am showing the state what has been marked as Defense Exhibit 44. All right, so this is what I want us to do with Defense Exhibit 44. Detective Ricketts, I'm going to allow you to listen to this, okay? And can you look up at the portion where you discuss with Chris Melton what's on his hands? Is that fair?
Yes.
Okay. And just to make sure we're clear, this recording, based on your prior testimony, this recording refreshed your recollection about Mr. Melton picking his hands, what was on his hands, things of that nature. Is that fair to say?
Yes.
Okay, excellent. May I approach the witness, Your Honor? Okay. There you go. And I just stopped it where you stopped it. So if you...
Okay.
And if you would, once you hear that portion of the recording, just let us know the timestamps.
As that was anything. Like, I thought that, that's why we didn't say that.
Okay. What's that? You turn audio up as you need it. Your choice. If you could find it by speeding through it, we'll take that. If you need to listen to it, we'll take that. We just want to know where in that recording do we talk.
My recollection is toward the very end of the interview, which is pretty lengthy.
You can speed through it. I think I can give you the times for the ending of the interview. But yes, you can speed through it. All right, and the interview ending time is 42:08, if that will help you. 42:08 is the interview ending time, if that will help you. And Your Honor, if you would like to just avoid the jury sitting in the box, if you would like to give them a break while Detective Ricketts looks over that video, I have no objection to saying.
Thank you.
Yes, ma'am. Would a transcript help you find it faster, Detective Ricketts? Sure. I have a transcript for you as well.
Mr. Cruz.
Can you go to minute mark 40:48 through 40:49? Or 40:48, start at 40:48 and play it to 40:51. Justin. Thank you. Did you hear it? Yes. Okay. And you would agree that the statement that you made that led you to say that Chris Melton was picking things off of his hand, that he had different glues on his hands, was you need to wash those things up or anything. Is that correct?
Yeah, I believe I said, do you want to wash those things up?
Okay. Can you write that on the board? Do you want to wash those things up? Okay. And that is minute mark, you would agree, 40:48 to 40:51?
Yes, sir. That was helpful. Thank you.
You're welcome. Your Honor, I would move to admit defense exhibit 44 for the purposes of moving minute mark 40:48 through 40:51 into evidence.
Any objection?
No, Your Honor.
It is admitted.
Thank you, Your Honor.
And just to clarify for the record, is it my understanding, Mr. Cruz, that you're just seeking to admit those 3 seconds of the recording?
Right.
Okay.
For now, we're gonna admit more, but for now, just those 3 seconds. So, the statement, do you want to wash those things up? It says nothing about picking at fingernails. Is that correct?
That's correct.
Okay, and we've agreed that it's been 9,153 days, right?
Correct.
It says nothing about picking paint off of his skin, or picking glue off of his skin. Is that correct?
No, sir.
Okay, it says nothing about whether the glue was transparent or not, does it?
No.
Okay, would you be shocked to learn that Mr. Melton testified himself that he had plumber's cement on his hands?
No.
Okay, but that would be inconsistent with the testimony that you just gave the jury here today. Is that correct?
No, plumber's glue, plumber's cement, I would categorize as the same thing.
Well, he said 3, and he included plumber's glue.
Okay.
Okay? So would that testimony differ from the testimony that you just gave the jury on direct examination?
I don't think so.
That's fair. 9,153 days. We don't remember the Super Bowl. We don't remember the World Series. We don't remember our favorite song. But the simple statement, do you want to wash those things up, led you to tell the jury that Chris Melton's hands, you could see them. Is that right?
Yes, sir. It was the totality of this interview, sitting in that interview room, looking across the table at a dad and a son. And Chris, as he would make comments, you can hear that. He'll tone in, tone out, not a person to show emotion or things of that nature, but would sit and pick at his hands and pull. And it was just, I won't say a nervous tick, but it was what he was trying to do, I think, to keep his focus, would be my opinion. That is what we're talking about with there. We're ending the end of the interview where I've got to get fingerprints, and I just asked him, hey, do you want to wash those things up? Do you want to get that stuff off of there? That's all it was. If he'd have had a high amount of semen or whatever else on his hands.
Objection, non-responsive and narrative.
I'm going to sustain the objection with regard to non-responsive, the end of this particular statement. You may continue.
What you just stated, that's nowhere in the police report, is it?
No,
You have your reports, is that right?
that's correct.
It is not in the audio recording you heard, is that correct?
That's correct.
Okay. And as far as the evidence that you've personally provided in this case, the very first time you've ever made that statement is before this jury here today, is that correct?
What do you mean?
Sure. Based on your notes and based on the audio recording. You had never said before that Mr. Melton was picking at his hands, picking items off of his hands. Is that correct?
No.
Okay. But we would agree 9,153 days later you stated. Is that correct?
That's correct.
Thank you. Now, you also stated on direct examination that Mr. Melton wanted Miss Baker at his, excuse me, let me rephrase that. You also stated on direct that Miss Baker wanted Mr. Melton at her birthday party on Friday. Is that correct?
That's correct.
Did you interview Miss Virginia Baker?
No, I don't believe so.
Okay. So you're not aware that, but you did not interview Miss Virginia Baker, is that correct?
No, the only people I did were some roommates and other folks who corroborated what Chris said for me there.
Okay. Do you know if Chris Melton had talked to those roommates and told those roommates the same thing he told you?
I would have to look at my notes, but one of them mentioned it to me in her statement, I believe.
Sure, look at your notes. And tell us the date that she mentions that.
Give me one more second, just to make sure I would give you a good, direct answer.
Absolutely.
So those statements aren't going to be about the birthday party, and I don't know if you want me to read what I've got about the relationship with Tara. I don't want to say it. So I don't have anyone doing what you said. So I'll say no to that because that's on a different relationship page. I don't know if you want me to bring that up or not. So
No. So the specific answer to my question is no. No one else said anything about Mr. Melton's.
to my knowledge, no, then it was a different statement.
So the statement that you gave on direct is inconsistent with your notes.
Which was the statement I made on direct?
That Mr. Melton and Ms. Baker had plans on Saturday. Is that correct?
That's correct.
Okay. And I asked you, and I'm gonna paraphrase it, had that been corroborated by anybody else? Is that correct?
That's correct.
Okay. And your answer to that question is no.
Yes, that direct question, yes.
Okay. So you just simply took Chris Melton's word for it. Is that fair to say?
Yes, that was my point there.
Do you think in a criminal investigation, especially involving murder, aggravated assault, burglary, aggravated sodomy, arson, it is important to take more than someone's word for it? Is that fair to say?
Yes.
And I believe the question I asked you was about the party Friday. That's what we were talking about, not Saturday, the party Friday.
Yes, sir.
So just to clarify the record, the fact that Tara wanted Mr. Melton at the party Friday, that was based on Mr. Melton's word. Is that correct?
That's correct.
Okay. And the same for Saturday, is that right?
Yes.
Okay. And Mr. Melton did not provide any proof of any plans he had with Ms. Baker. Is that correct?
Did not.
I'm going to go into a line of questioning that the Honorable Court has advised us to be cautious about. Can me and Mr. Yalamachili approach the bench, please? All right, so you know Mr. Melton's parents' address, is that correct? Okay, you don't have to say the address. And Ms. Baker's address was 1C. Your Honor, I am asking the Honorable Court to take judicial notice under OCGA 24-2-201B 2 of the distance between Mr. McCourty's parents' home and Ms. Baker's home.
Judge, judicial notice does not bring a fact before a jury as a trier of fact in a jury trial. It is just something that the court can take notice of. It is if it is a previously established fact. So the method in which Mr. Cruz is attempting to use judicial notice, I don't think is proper.
That is not true, Your Honor. I have case law 1, but I'll read the statute. The statute provides B, a judicially noticed fact shall be a fact which is not subject to reasonable dispute, and that it is either, and we're under subsection 2, capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. And C says a court may take judicial notice whether or not requested by a party. And D is the language that, shows that the state's argument is not the law. A court shall, there's no discretion here, a court shall take judicial notice if requested by a party and provided with the necessary information. The limitation that the state just put on the Honorable Court's ability to take judicial notice is not a limitation in the law, Your Honor. We're relying on the statute. We would like to show the state, if okay, the statute as well as the item we would like judicially noticed.
I'm familiar with the law, Judge.
And may I approach, Your Honor? Approach you.
May you approach the court?
Yes, ma'am, to provide you with these documents and the law.
I don't need the law, Mr. Cruz. Any other arguments, sir?
No, ma'am.
All right. I'm going to sustain the state's objection. I agree with the state's rendition of the statute and the appropriate things that are to be used for judicial notice. I'm going to sustain their objection.
Yes, ma'am. Do you have your phone?
I do.
Okay. Can you go to Google for us, please?
I can turn it back on. It's off. Is that okay with the court?
I don't have any prohibition against that.
Okay. I have it on flight mode.
I'm not objecting in this trial. If there's an objection, I will hear it.
I just don't want to upset you, ma'am.
No, sir. Thank you.
Okay, I've got a signal now.
Okay. Can you go to Google Maps or whatever you use, Apple Maps, Google Maps, whichever you prefer?
Okay.
And I'm going to approach you. Sure. And for the purposes of the record, I am going to provide Detective Ricketts with Chris Melton's parents' address. Can you put the distance from Melton parents to Tara's home? Yeah, under law.
Give me the directions.
Don't give me the directions. Do you have it pulled up?
I have the address.
All right, and do directions to 160 Fund Drive, Athens, Georgia, 30605. Chris Melton's parents' home. And when you pull it up, I won't ask you about the time. I believe that that's not competent evidence, but I am going to ask you about the distance. Is that fair?
Sure.
Okay. All right. To Tara Baker's home. You would agree that on one route, the distance from Mr. Melton's parents' home to Miss Baker's home is 39.6 miles. Is that correct?
Yes, sir. I'm getting an ad pop up, but
Sure. Circle this.
yes, sir. I'm getting 40 miles.
Okay. 39.6 added up, 39.9 rounded up. Rounded up. Okay, perfect. All right. And I want to be specific. So 39.6, is that correct?
Yes, sir. This Google's giving me 40 on the nose.
Even?
Yes, sir.
Okay, we'll take what Google gives you. Put 40 miles.
I can switch routes and see for you if you like.
No, you're fine. All right. Do you recall talking to a Mr. Lindsey Baker?
I'd have to look at my notes to double check.
Okay, sure. And I don't believe that would be in your individual reports. And I don't know what all notes you have, but
I pretty much only have anything that my name is on. I don't have anything.
anything else? Well, let me ask you this. Do you know who Mr. Baker is?
No, sir.
Okay.
Off the top of my head, no, sir.
That is fine. Did you ever visit Mr. Melton's parents' home?
I did not.
Okay, but he did tell you at the time that Miss Baker was killed, he was staying at the parents' home. Is that right?
Correction. Could you repeat that question for me one more time?
Sure.
Did you say the Baker's residence?
No, and I might have said the Baker's
Yeah, I think
residence.
so.
So please forgive
You
me.
go to the Baker's home.
The Melton residence.
No, I did not. Someone else did that.
Okay. So you don't know the layout of the home.
I do not.
Okay. But Mr. Melton did tell you he was staying in the basement of the home. Is that right?
No, he just told me he was staying there. I didn't. He never told me where in the house he was staying. He just said he was staying at his parents' house. And on that same audio, you can hear his dad at the beginning say he's been staying there for pretty much the week.
Okay.
Hear him chime in.
But to your personal knowledge, you don't know where in the home he was
No,
staying?
I don't have any information on that. May I turn my phone back off?
Absolutely.
Because it will.
Now, you had opportunity to listen to the recording between yourself and Mr. Melton, right?
Yes, sir.
And we've agreed that that interview took place on January 19, 2001. Is that right?
That's correct.
And you asked Chris during the interview, how did you start your day today, or what kind of went on today for you? Do you recall asking that question? And Chris was able to explain his day in a calm and clear tone. Is that correct?
Yes.
He was not unable to answer any question. Is that correct?
I believe everything I asked him, he did answer.
Okay. He was not fumbling over his words. Is that right?
No, there are times in that recording that he will get quiet. He won't say anything.
Okay.
But he was able to get through his conversation.
But we could both agree that he wasn't frantically crying. Is that right?
No, he was not.
But he did tell you that he was asked to identify the body that day. Is that right?
That's correct. Earlier in the day.
Okay. And we agree that Ms. Baker died on the same day. Is that right?
That's correct.
And he also described her as his borderline fiance. Is that correct?
That's correct.
He even spelled the name of Truck Customs for you. Do you recall that?
I did. I was having an issue with it. I believe in that tape, I asked him to spell it for me.
Mm-hmm.
It'd be the second interview I did because I was having a hard time finding it. But that could be the second interview I did with him where I asked him to spell it.
Would hearing the first interview refresh your recollection? Or excuse me, let me change that. Would hearing him spell out Truck Customs refresh your recollection?
Sure, if that's in the first one, I'll just agree with you. It did. He did spell it for me in one of those two because in my report I had it wrong.
Sure.
And I had to get it corrected.
So let me ask the question this way. You would not disagree that on January 19, 2001, Mr. Melton spelled out Truck Customs for you during that interview?
I would agree with you on that.
Now, while detailing his day, Chris stated that Josh came to his house after he woke up on the morning of Miss Baker's death. Is that fair?
Say that one more time.
Sure. While he was detailing his day to you, he stated that Josh came to his house on the morning of Ms. Baker's death.
Yes, sir. That's how I took it.
And Chris stated that him and Josh only worked together. Is that correct?
What do you mean by only work together? Is the two of them?
They
or-
don't have any personal relationship. Is that correct?
He advised that they work together, yes.
And the address Josh came to pick up Mr. Melton was from Mr. Melton's home. Is that fair to say?
That's correct.
Okay. We've discussed that address. And they drove to a company called Nash Plumbing together. Is that fair?
Correct.
And this was in Chris's truck.
That's correct.
Chris says that they arrived at Nash Plumbing between 7:35 and 7:40. Is that right?
Yes.
Pen. Thank you. And he stated while at Nash Plumbing, they loaded up. Is that correct?
We went there to get their supplies.
Would you agree that during the course of your investigation, you were unable to speak with any supervisor that confirmed that Josh and Chris were at Nash Plumbing between 7 a.m. and 9 a.m. on January 19, 2001?
That's correct. I did not do that.
You were unable to speak with any coworkers that confirmed Josh and Chris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m. on January 19, 2001?
That's correct. I was not assigned to do that.
You were unable to speak with any receptionists that could confirm that Josh and Chris were at Nash Plumbing between 7 a.m. and 9 a.m. on January 19, 2001?
That's correct.
You were unable to speak with any eyewitnesses that confirmed Josh and Chris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m. on January 19, 2001?
That's correct.
You were unable to obtain any sign-in logs or visitor logs confirming their presence at Nash Plumbing at all on January 19, 2001?
You're correct.
You were unable to obtain any business records that confirmed that Chris and Josh went to Nash Plumbing on January 19, 2001?
Yes, that's correct.
Now, Chris claimed they loaded up. We've agreed on that. Is that right?
Yes, sir.
But you were unable to obtain any signed delivery or pickup receipts that supported that Chris was at Nash Plumbing on January 19, 2001. Is that right?
That's correct.
You were unable to obtain any invoices supporting that Chris Melton was at Nash Plumbing on January 19, 2001. Is that correct?
You're correct.
And although they picked up supplies, you were unable to obtain any work orders that supported that Chris was at Nash Plumbing any time on January 19, 2001.
That's correct.
Now, in regards to Chris and Josh saying they worked together, Chris told you that Josh was his employee. Is that fair to say?
Yes.
Okay. You were not able to obtain any payroll stubs to confirm that they were employed together, were you?
Yes, sir. I was not assigned to do that.
Is that a no?
Yes, it's a no.
You did not collect any W-2s or 1099s confirming their employment together?
I did not.
Mr. Melton didn't even provide you with an employment contract showing that those two worked together.
No, he did not.
Did you obtain any work-related emails between the two?
No.
And I know it was 2001, but you didn't collect any work-related text messages between Josh and Chris.
No, sir.
Correct? You were unable to interview any third-party co-workers that confirmed that Chris and Josh worked together. Is that correct?
That's correct.
And Chris's father was with Chris during the January 19th interview. Is that right?
He was.
And during that interview, not even Chris's father confirmed that Josh and Chris worked together. Is that correct?
No, he was not asked to.
So we simply took Chris Melton's word for it.
At that point of the interview, that's what I did. Other folks were assigned to follow up on those things.
Yes, sir. Now, during your interview with Chris, he told you that his home and Josh's home was less than one mile apart. Is that correct?
I don't know if he gave me a direct. He did say they lived near each other,
Okay.
if I recall that correctly.
Do you recall Chris stating, drove back to their house, talked to let Josh off that little guy. He lives like a mile from me. Do you remember?
Yes, sir.
And obviously, Chris knew where Josh lived. Josh knew where Chris lived. Is that fair?
Yes, sir.
Okay. And Detective Ricketts, you personally never investigated whether Josh and Chris were personal friends. Is that right?
I did not.
Now, Chris stated after going to Nash Plumbing, he went to Truck Customs. Is that fair?
Yes. If you'd like to refer my notes, but yes, that would be the second location.
Justin. Yes, right where it gets at the bottom. And go to the next page. We're going to start at the top. Question for you, Detective Ricketts. Have you met with the state in this case?
I have.
Did you take notes of your meeting with the state?
I did not.
And then we'll go to the next page. All right, Detective Ricketts, what we're going to do for purposes of the record, I have a whiteboard here. We're going to write your name at the top, okay?
All right.
And we're going to discuss the information that you were given. Is that fair? All right, so Ricketts at the top. Two T's. You write it big. All right. Then put an underline here, and we're going to write Chris, and we're going to write Josh. All right, then a line down. And then write Chris here, write Josh there. Thank you for your patience.
No worries.
All right, so we're going to write, and you let me know if this is accurate. Very first place Chris says is Nash Plumbing. Is that correct?
Yeah, on the 19th?
Correct.
Yes.
All right, can you write Nash Plumbing here under Chris?
And for purpose of this, you may want to put the 19th on there because on the 21st, he added a location. So I don't know if you want to differentiate that or not.
So the first place is Nash Plumbing.
Yes, sir.
Okay. All right, put a hyphen after Nash Plumbing. And Nash Plumbing was unconfirmed. Is that right?
By me, yes, sir.
Okay. And put unconfirmed after Nash Plumbing. I'm about to go fast, okay. All right, after Nash Plumbing, he stated that he went to Truck Customs. Is that correct?
Can I? Yes, Truck Customs is number 2. Yes, sir.
Truck Customs. And he stated that they went to Truck Customs at 9:30 a.m. or earlier.
May I refer to these?
Absolutely. And Detective Ricketts, to be fair, you can use the 19th or the 21st, whichever one you would like to use as far as the
He
time.
said around 9:30. Yes, sir.
So put 9:30. And I want to emphasize this language. He didn't say 9:30 or later. He said 9:30 or earlier. Is that right? And it's page 1 of 2.
He says, or maybe earlier. Yes, sir. You're correct.
Or earlier. Now, after leaving Truck Customs, Chris advised that him and Josh went to a home in Grayson. Is that correct?
Yes, that's correct.
And forgive me, we skipped something. He eventually tells you that he went to the bank, right?
Yes, sir.
Just put bank right there. Bank right here. Did you speak with anyone other than Josh to confirm that Chris was in Grayson, Georgia on the day of Ms. Baker's murder?
I did not.
Did Chris provide any documentation confirming that he worked on or went to a home in Grayson, Georgia on the day of Ms. Baker's murder?
To me, no.
Okay. So just for you, we just took his word for it. Is that right?
For this on the day of, yes, it's preliminary, and then Sunday the same.
Yes, sir. You can put Grayson, Georgia after Truck Customs. Now, excluding Grayson, we could safely say that Ms. Baker was killed between 7 a.m. and 11:32 a.m. Is that a fair window? And I can ask it a different way. At 11:32 a.m., the fire was reported. Would you agree with that?
Fire was reported at, I don't have notes on this, but at 9:00 whatever, the clock on her wall no longer worked.
Okay, perfect. That's fine. We could say 7 to 9, whatever. So we'll say 7 a.m. to 9 a.m. Is that
I would
fair?
be more comfortable at that time.
Okay, excellent. And you're aware at 7:45 a.m., a neighbor of Ms. Baker said they saw a white guy running through their backyard away from Ms. Baker's home. Is that correct?
Yes, that's not in my interview,
But you are aware of that?
I heard that, yes, sir.
Okay. So it's safe to say that if that person was the murderer of Ms. Baker, it's safe to say that the murder occurred before 7:45 a.m. Is that correct?
If that's the murderer.
Correct. Is that fair to say?
Yes. Could be, yes.
So you knew that it was very important to confirm where Chris Melton, well, let me change that. It's fair to say that it would be very important to confirm Mr. Melton's whereabouts before 9 a.m. Is that fair?
Yes.
And for his alibi, he says, I start my day at my parents' house. Is that fair? And between, because this is a specific time, he says between 7:35 and 7:40, right? At Nash Plumbing, is that correct?
7:30 to 7:45.
Okay. So based on what he told you, he's saying I'm either at Nash Plumbing or I'm at Truck Customs. Is that right? 9:30 or earlier. Is that correct?
Yes.
So after speaking with Chris, ACCPD's job becomes confirming Chris's alibi. Would you agree?
Yes.
Because if his alibi is false, would you agree that would suggest consciousness of guilt? Is that fair to say? Let me rephrase it.
Yeah,
Let me rephrase it in a better manner. If Chris Melton lied about his alibi, that would be significant in your investigation. Is that fair to say?
Yes.
Now, we can agree that you actually took the next steps to trying to confirm Chris Melton's alibi. Is that fair?
Yes, I was part of that, but there were other detectives doing that also.
Yes, sir. You spoke with Josh McCurdy. Is that correct?
Yes.
You spoke with Mr. Bill Teeter. Is that right?
I did over the phone.
Okay. And you spoke with Josh McCurdy not on the 19th, but the next day, January 20th.
That's correct.
And it goes without saying, but it's the day after Miss Baker's death.
That's correct.
Now, Josh also told you they started their day at Nash Plumbing. Is that correct?
Yes.
Okay. And you'll put Nash Plumbing here. And we've agreed that Nash Plumbing was unconfirmed.
From me, yes.
And if you'll put unconfirmed next to Nash Plumbing. Then after leaving Nash Plumbing, Josh says we go to Chick-fil-A for breakfast. Is that fair?
Yes, Josh brought Chick-fil-A up.
Say that one more time.
Josh brought Chick-fil-A up.
Okay, thank you. And if we could write Chick-fil-A under Nash Plumbing. And then Josh says at around 8 a.m., they went to a house in Grayson to check for leaks.
Yes, he gave 8 a.m. checking for leaks.
Okay.
Said behind the fire department on Georgia 20.
And I think we've already agreed Grayson, Georgia is unconfirmed for Chris. Is that right?
From me, yes.
If you put unconfirmed there. And then Grayson, Georgia here, unconfirmed. Or Grayson, Georgia, 8 a.m. And then Josh says from Grayson, they go to Forsyth.
That's correct.
And did you confirm that Josh or Chris Melton were at Forsyth?
I did not.
Okay. Now, they did provide you with the name of Truck Customs. I believe he may have even provided you with the address to Truck Customs. Is that correct?
He may not have advised me of it, but we did get the address for Truck Customs.
Perfect. But he didn't provide you with the names of anybody he spoke with in Grayson, did he?
Grayson, no. I don't know if he did with other detectives, but he did not with me. That's not what was sure.
So Grayson is unconfirmed, Chick-fil-A is unconfirmed. Is that fair?
That's correct.
Okay. You put unconfirmed there. Grayson is unconfirmed. Chick-fil-A is unconfirmed.
Just by me, so you got my name on it. So yes, sir, that's correct.
Correct. So you would agree between 7 a.m. and 9 a.m., both Chris is unaccounted for by you and Josh is unaccounted for by you.
Have both their statements given at different times that corroborate where the other one was. So on this preliminary part of the investigation, we had a general idea of where they were, and that's what we were going with at that time.
Well, when it comes to murder, aggravated assault, aggravated sodomy, we want to have facts. Is that fair to say?
Correct. And in this early stage, the 19th, 20th, 21st, we're trying to get information on 3. So a lot of times when you're taking these cases in the first, you'll get somebody says this, as Chris did. He left information out on Wachovia remembered it. Now, people forget things like that all the time. You've got Josh's, and then you interview these other ones, and all you're doing is taking and aligning their timeline. During that first 3 days, that's what we were doing, is just aligning that timeline and getting the stories where everybody was, and then getting DNA, fingerprints, and things of that nature in order to work the case to push on to the crime lab.
Correct. So I ask you this. At that time, you were a law enforcement officer. Is that right?
That's correct.
And your job was to protect this community. Is that correct?
Yes, sir.
So as we talk today, why are you defending Chris Mellon?
I'm defending the information that I gathered on the 19th, 20th, and the 21st.
Well, wouldn't it be an issue if Chris Melton says that they went to Grayson after 9:30 and Josh McCourty says that they went to Grayson at 8 a.m.?
Yes, but from the Wachovia video and whatever else, we've got that stamp at 9:08.
You're aware of the Wachovia video, is that right?
Yes, sir.
Okay, but our timeline is 7 a.m. to 9 a.m. 9:08 is outside of our murder timeline. We're saying 7 a.m. to 9 a.m. Josh and Chris are unaccounted for. Is that fair?
Well, yes, if you want to say it that way, but to be in the Chick-fil-A is right next door to that also. To be in that area in under an hour and 15 minutes from Fawn Road in Athens on morning rush on a Friday, it's going to be very difficult to do.
My question again, why are we defending Chris Melton?
Again, I'm defending what we were doing in these first 3 days of this investigation.
But Detective Ricketts, you've told us that Chris's parents' home is only 40 miles away from Miss Baker's home. And you've already said that January 19, 2001 was 9,000 days ago. How do you know what the traffic was like, Detective Ricketts?
The route that we're going to their house, I drive a good bit, but I'll just say you're going to do it in an hour. During that time frame, someone from Athens, Clark County, I'm not sure who did that drive, it's going to take you approximately that amount of time. Now, again, not defending Chris, I'm explaining to you how investigations in those early 72 hours are done with trying to line up those statements.
Copy of this redacted. Okay. Course indulgence. And I just want to make sure I understand your testimony. Your testimony is it takes an hour to get from Mr. Melton's parents' home to Miss Baker's home?
Yes, with traffic, I'm saying yes.
Well, hold on. Let's be clear.
But when I Google mapped it just a minute ago for you on the record, it said 1 hour and 4 minutes to do that 40 miles. So that was at 9:30, 10 o'clock in the morning past rush hour.
But you would agree in 2001, Athens wasn't the city it is now, right?
Judge, I would ask, Detective Ricketts was in the middle of an answer. Mr. Cruz cut him off with his next question. I'd ask Detective Ricketts be able to finish his response.
We're going to allow him to finish his response, and then you may question.
Sure.
Is there anything you wanted to add? You may.
No, I was just going off the recollection of what I pulled up at 10:30 in the morning on Google for right now. And yes, I'm sure traffic was different in 2001.
Well, let's talk about this. It's 10:30. If, and we've already discussed this, if the person seen running committed this crime, he would have been traveling before 7:45. Is that fair?
Okay, yes, sir.
Okay. And he could have been traveling, we don't know, at 6:45 a.m. Is that right?
I don't know.
Okay. But you do know, as you just told this jury, that at 10:30 on February 10th, 2026, it's an hour and 4 minute drive.
Yes, sir, only because you asked me to look it up.
Sure.
That's the only reason I know
But
that.
that's irrelevant to our conversation about January 19th, 2001. Is that fair to say?
Okay.
Is that fair to say? Would you agree?
Yes, sir. That'll be fine.
Now, we have a discrepancy in the alibis, right? We have Josh saying Chick-fil-A. We have Mr. Melton not saying Chick-fil-A. Is that fair?
Yes, sir. They're both saying that. One saying Chick-fil-A, one saying that.
Okay. One saying what?
One saying Chick-fil-A and one saying the Wachovia Bank.
So you're saying the bank and Wachovia are next to each other?
They're close.
So how do we explain Josh saying Chick-fil-A before 8 a.m. and Chris saying Chick-fil-A after 9 a.m.?
Say that again.
Sure. Your testimony was that the Wachovia is right next to the bank. Is that fair?
Yes, they're close together.
And you just made the statement that Josh said Chick-fil-A, Chris said bank. Is that fair?
Yes,
Okay. Josh said Chick-fil-A before 8 a.m. Is that correct?
he did.
Okay. Chris says bank after 9 a.m. Is that correct?
Yes.
Okay. So that's a discrepancy. Is that fair?
Or both things could be true. They could have gone by that Chick-fil-A and then gone back to the bank. The bank doesn't open till 9.
So my question is this: Why are you defending Chris Melton?
I'm not. You're asking for information, and I'm trying to give it to you from the 72 hours that we were working the very first. Now, in this, from the 19th, 20th, and 21st, not even working this case, I believe we did 20-some-odd. I did 20-some-odd interviews during that time. Typically, this is what happens during those first 72 hours, is just trying to get timelines. And then over time, you start pulling those timelines together.
Do you know if Mr. Faust got that courtesy?
I don't work here anymore, sir, so I don't.
But we can agree that Chris Melton got that courtesy.
I don't think Chris Melton got the courtesy. I think we worked the case.
Well, officer, we just talked about this. You said that you explained that the reason Josh said Chick-fil-A and Chris said the bank, you said two things could be true at once. You were saying they could have went, and this is your testimony, they could have went to, I guess, to Chick-fil-A by the bank first, and then after 9 a.m. went back to the bank. That was your testimony. Is that right?
Yeah, when we're looking at this during this time frame, so when you take somebody who's been involved in a crime or whatever else, and they've been a victim of a crime, and they're giving witness statements, things are recalled the next day or so. He forgot Wachovia, which is a timestamp thing. Don't know why he forgot that until Sunday. Don't know. Normal people, through the course of doing investigations for almost 35 years, do not walk through and timestamp their day. They can give you approximates and say this and that. The majority of people I've interviewed for homicides, whatever else, and not saying at the bank I was at 9:08, whatever else. Now, I understand what you're saying. This was a timeline in 3 days where we're trying to put people where they're supposed to be, and I'm testifying to those 3 days of what I did on those. And some of it, like I've told you, I didn't do those interviews, so I cannot answer that for you.
Sure.
We're trying to put people in those spots and then see what evidence moves from there.
You would agree that Ms. Baker is the victim in this case?
100%.
Since January 19, 2001, Ms. Baker was the victim. Is that correct?
100%.
And her family were victims. Is that correct?
100%.
And ACCPD's job as law enforcement officers are to make sure the victims are taken care of. Is that right?
Yes.
And to solve those crimes, correct?
Yes.
And when questions pop up as a law enforcement officer, your job is to answer those questions. Is that right?
Yes, sir.
Your job is not to explain away those questions. Would you agree?
I'm not. I'm explaining away 72 hours.
I'm not saying my specific question is your job is not to explain away those questions. I'm not speaking.
I'm sorry. I took it as you were implying, but no, it's not. I agree with you.
Now, on January 20th, 2001, you spoke with Mr. Bill Teeter. Is that correct?
Yes, sir, over the phone.
And Bill Teeter is the gentleman that worked at Truck Customs.
Yes, sir.
Okay. You had no reason to believe whatsoever that Mr. Teeter and Mr. Melton were personal friends.
At that time, no. On the 21st, no.
Okay. And based on your interaction with Mr. Teeter, you understand that Chris Melton's relationship with Mr. Teeter was solely as a customer.
At that time, yes, sir.
And you would agree that gives Mr. Teeter a certain type of credibility, right?
Yes.
He would have no reason to lie for Chris Melton. Is that fair?
Yes.
Okay. He would have no reason to try to cover up for Chris Melton. Is that fair?
That's correct.
Okay. And Mr. Teeter told you that Chris came to his shop around 10 a.m. Is that right?
Yes, sir. I believe that's correct.
Cross here. Put Teeter in that box. So we could say that Chris's trip to Truck Customs was confirmed. Is that fair?
Yes, sir. He said Chris had to come by there once in the morning around 10 a.m. The only appointment Chris had that day was for 4 o'clock. The initial appointment in the morning, the reason he said, if
10 a.m.
on the tape,
That's from 10 a.m.
is it was just to show up for a measurement, and that was a stop-in. They measure the compartment or whatever else, and then they go, and then would come back for that appointment later in the day.
Okay.
But the appointment was for 4 o'clock.
So we've confirmed around 10 a.m., correct? But we still have not confirmed that window between 7 a.m. and 9 a.m. Is that fair?
Yes, sir.
So based on what Mr. Teeter told you, it is fair to say when Chris Melton told you that he went to Truck Customs at 9:30 or earlier, that was not true. Is that correct?
His timeline was off on that one, because Truck Customs, if he'd have left the Wachovia to go there, he would have been there right around 10.
Detective, if you can answer this question.
Sure.
Do you feel the need to explain for Chris Melton?
Again, you're asking about a timeline,
Sure.
and I'm trying to explain to you, from where that Wachovia was to Truck Customs is not a very far.
Well, this was my question. My question was, and I'll ask it a different way. Chris said he was at Truck Customs from 9:30 or earlier. Do you agree?
That's what he said, yes, sir.
Okay. Bill Teeter said that he was at Truck Customs around 10 a.m.
That's correct.
Okay. And you would agree this is significant because once you told Chris Melton that you talked to Bill Teeter, he changed the time that he was at Truck Customs to 11 to 12:30 a.m. Is that fair to say?
The second interview is when he mentioned that he went to Wachovia.
Officer, we're talking about Truck Customs.
Yes.
Okay.
So, and that's why I believe his timeline just slid just a little bit, but that was a timeline from 9:30 to 10:30.
Did Mr. Faust get the same courtesy from law enforcement to explain any discrepancies he may have had?
Judge, I'm going to object to the form of the question as being argumentative as well as lack of personal knowledge. As Detective Ricketts has already said, he never worked the case at the point that Mr. Faust entered it.
I will withdraw the question, Your Honor.
I'm going to sustain that objection.
Yes, ma'am. But after you told Mr. Melton that you talked to Mr. Teeter, Chris Melton then changed his time to somewhere between 11 a.m. and 12:30 a.m. Is that correct?
I don't know if I told Chris that I talked to Bill or not. I cannot testify to that. Chris told us about that, though, the evening he came in and brought up Wachovia, which in a normal investigation, somebody bringing something else up they did that day is not that far out of the realm of possibility.
Okay. So this is possibility here. You say this would be normal for Mr. Melton?
Yes, sir.
Okay. On the morning that Miss Tara Baker was killed, this is normal?
What do you mean by normal?
Sure. You said this is not outside the realm of possibility.
I'm talking generalized in an investigation when somebody comes back in with a time. Like I said before, people don't roll through their day now pretty much with time stamping, especially in 2001. With phones and everything we have now, you can time stamp pretty stinking well. I'm just saying that's along the realm of that kind of ballpark window that we're looking for just to keep things for that initial 72 hours.
Well, I would like to talk about police. Police, they live in timestamps. Is that correct?
Yes, sir.
Okay, police, they confirm. If you say you went somewhere, a police officer's job is to confirm it, correct?
That's correct.
Because you got to give answers to the community. Is that fair?
Yes, sir.
And you have to give answers to the family. Is that right?
That's correct.
And if the family asks you, where was Chris Melton at 8 a.m., an appropriate answer isn't, well, in the general realm of possibilities, he could have been anywhere between these places. Is that fair to say?
I understand what you're saying, and yes, that is fair to say. And in that first 72 hours, we're putting in on the timestamps of what's happening in that first 72 hours.
Yes, sir. Would you have any reason to disagree with me in the multiple interviews you conducted with Chris Melton? He has never stated that he went to Chick-fil-A.
No, sir, he is not to me. And again, he may have to some other investigators after that, but not to me.
Sure. And we've already agreed that you never personally confirmed that Josh went to Chick-fil-A, right? That's unconfirmed.
By me, yes, sir.
And we've agreed that you talked to Chris the second time on January 21st, 2001. Is that right? Now, his parents were present. Well, his father was present at the interview. Is that fair?
Yes, they drove him there. But at the interview, I believe it's just Detective Newton and myself.
Now, during your interview with Josh, Josh told you that he had worked with Chris for a year. Do you recall Josh making that statement?
Yes, sir.
However, Chris told you that he had only met Josh in December of 2020. Is that fair? I'm sorry, December of 2000. Please forgive me.
I understand that. Done that a lot lately. I don't know. Is that in my notes?
It's in the recording.
That's a good possibility. Then I won't argue that with you.
So, December 2000 was just a month from Miss Baker's death. Is that fair to say?
Yes, sir.
Okay. And if you can, write Chris 1 month, Josh 1 year. And this is a very important area for us, officer, because I do think you did. I think you did the best you could with the facts that you were given under the circumstances. So I do want to say that, and I do appreciate your service tremendously. Okay.
Okay.
But I do want to ask you about the interview on January 21st, 2001, in regards to Chris's statement about going to Wachovia Bank. Okay.
Okay.
Now, he told you that he was in the bank on Friday, January 19th for 35 minutes. Is that correct? And that would be on the recorded interview if you don't
He
see.
said he's in the bank for around 30 minutes. That's just what I typed in my notes.
Would you have any reason to disagree that he specifically said 35 minutes?
I put 30 in my notes, but 35 won't be a...
Would you like to hear the audio recording?
No, sir, I'm fine.
And if that's true, that Chris Melton spent 35 minutes in the bank on Friday, January 19th, you would agree that it's not an insignificant amount of time to spend in the bank. Is that right?
No, sir.
Okay. However, Josh never mentions going to the bank for 35 minutes with Chris, does he?
He does not.
In fact, he never mentions the bank at all. Is that right?
He does not.
Now, we've agreed that Chris' father was with him on the January 19th and January 21st interview. Is that fair?
Yes, sir. I don't believe he sat in on the 21st. He did sit in on the 19th.
Okay, so we'll discuss the 19th. Chris's father never agreed with the statement that Chris left his home between 7 a.m. and 8 a.m. on January 19th while he was present in an interview with you.
No, sir, not in that interview.
And during the weekend of January 19th, 2001, you did not speak with Mr. Melton's mother. Is that correct?
I did not.
Now, Dad knows that Tara has passed away, Mr. Melton's dad. Is that right?
Correct.
Okay. Dad knows that Mr. Melton's son has conducted an interview with law enforcement. Is that fair to say?
That's correct.
But Mom never calls you, Mr. Melton's mom, she never calls you and says, hey, Detective Ricketts, Chris was here with me that morning of Tara's death. Is that right?
No, sir, I did not do that.
Chris's parents don't reach out to law enforcement at all. Is that correct?
Except for coming to the police department twice voluntarily.
With Chris. Is that right? Only Josh and Chris are the only two people that stated that they left Chris Melton's parents' home around 7:15 a.m. Is that correct?
Yes.
And as of January 21st, 2001, with your involvement in the investigation, besides Josh, there were no other witnesses or documents confirming where Mr. Melton was between 7 a.m. and 9 a.m. on January 19, 2001.
Past the 21st, I cannot answer that, but from the 21st backwards, that's correct.
I believe you mentioned this on direct. You told Chris that Tara was probably sexually assaulted. Do you recall telling Chris that?
I did.
Okay. And when you told Chris that, he didn't start crying, did he?
No, sir.
Okay. Chris didn't become upset, did he?
No, sir.
Chris didn't say, I need a moment to myself. Is that fair?
No, numerous times during the interview he stopped, but no, sir, he did not.
Okay. And Chris didn't say, I hope you find who did this before I do. Is that correct?
Not on the 19th. Mentioned it on the 21st while we were at the jail at the jail at the phlebotomist, getting blood work done there. Just a statement he made in the hallway, but yes, sir, not during an interview or anything of that nature.
Can you show us that statement in your
It's
notes?
not in there, sir.
Okay. And we've already agreed that January 19th was over 9,000 days ago.
100%.
But Chris did ask you about the evidence in the case. Is that fair to say? And specifically, Detective Ricketts, Chris asked, in response to you telling Chris that Tara was sexually assaulted, did you find some stuff on her like semen? Do you recall Chris asking that question in response to you telling him that Ms. Baker had been sexually assaulted?
Yes, sir.
Did you find that odd that his response was about asking questions about the evidence?
No, for a couple reasons of sexual assaults, and that's one of the reasons John Newton and some of those folks were brought in for the sexual assault is if he's not sure she's been raped. Sometimes people wander down that road of how do you know that this person was sexually assaulted?
So can I ask you this before you finish? So it's normal to tell someone that's engaged or preparing to be engaged to another person that the love of their life has been sexually assaulted, and before they say anything.
Back to the form of the question as being argumentative, Judge, I'd also ask that the witness be allowed to finish the answer they were giving before they were interrupted by Mr. Cruz.
I think that is correct, actually. I'm going to sustain the objection. It is argumentative.
Yes, ma'am.
And if this witness chooses to finish his statement, he may. Otherwise, you may continue.
I withdraw the question.
Okay, yes, sir.
We've established that Chris Melton was in his vehicle on January 19, 2001. Is that correct?
At the police department?
No, the morning of January 19, 2001.
Yes, sir.
You would agree that you did not search Chris Melton's vehicle for the presence of Miss Baker's blood. Is that correct?
No, sir. From the 19th to the 21st, I did not.
Okay. Well, any other time past the 21st?
I did not. No, sir.
Would you agree that it's important to search a vehicle in a murder case? If it requires travel, let me add that. If the murder would require travel, you would agree that it's important to check the vehicle.
If you had a viable suspect at that time, then yes.
And Chris Melton was not a viable suspect at that time?
At that time, through everything we were getting was coming voluntarily, timeline was coming together. So at that time, by the 21st, he was not.
Well, what choice did he have, officer? Because you stated if he didn't agree to blood, you would have got a warrant.
Did not tell him that.
But it's true, right?
100% I would have. That was part of the interview when I started with him. At the very beginning of the tape, I make it very clear to Mr. Melton that he's there voluntarily and giving me a free and open statement. Because going into that interview, I don't know if he's a suspect or I don't know if he's a boyfriend of a victim. So as you start going down, that's what these 3 days are for, is to try to figure out what that person is and then what do I need to get to prosecute this.
Okay. So my question, my specific question to you, and if you can answer it with a yes or a no, he didn't have an option but to give blood. Is that right?
He did have an option, yes. At that time, he could have told me no.
And you would have got a search warrant and still got his blood?
We wouldn't have got blood that day, but it'd have been, I'd had to see a judge and move forward.
Okay.
Yes,
So you would have had his blood regardless?
yes, sir. But
Okay.
at that time, he was not told, hey, if you don't give this to me, I'm going to go get a warrant.
Sure, that's fair. And as far as coming to the police department voluntarily, were you the one that called the family and told them to come to Athens?
No, what do you mean by the family?
Sure, Miss Baker's family.
Oh, no, sir.
Okay, but you are aware that officers called them and told them to come to Athens. Is that correct?
I would 100% believe that, yes, sir.
Okay. But to your knowledge, no one called Chris and told Chris to come to Athens. Is that fair?
Well, Chris was paged by Miss Baker.
Law enforcement. We're talking about law enforcement.
Well, that's not the question he asked, Judge, and I think the witness is entitled to answer the question that he was asked.
We're going to allow him to answer.
Well, I withdraw the question, Your Honor. I withdraw that question. Did law enforcement call Chris Melton to come to Athens?
To my knowledge, no.
So he voluntarily went to Athens the day that he found out that his girlfriend was murdered?
Yes.
Okay. And you all asked Chris Melton to identify the body. Is that correct?
Lieutenant Durham, I believe, is the person who did that. I can't testify to who asked him, but yes, he was asked to identify the body.
That's fair. And Chris Melton, you stated that he didn't appear with a lawyer. Is that right?
He did not.
Okay. If he appeared with a lawyer, that would have looked a bit suspicious to you?
It would have been way out of the norm.
So if Chris is trying to avoid looking suspicious, the best thing to do is to appear voluntarily. Is that correct?
I don't believe so.
Now, you talked about the injuries to Chris Melton's hands taken on January 21st, 2001.
Yes, sir.
Okay. And Chris told you that those injuries came from punching a wall.
Yes, sir.
Okay, we would agree that that is drywall in that picture. Is that right?
It is.
Okay, and we would agree that injuries to Mr. Melton's hands look like scratches. Is that correct?
Looked like abrasions would be what I'd call them. Abrasions.
Okay. Help me, what's the difference between abrasions and scratches?
Abrasions is usually when you hit something and it slides, it's open. A scratch is usually a line or whatever else, and abrasion is usually wider open. So if you look at the picture, there's more of an abrasion, a hit, that kind of thing.
Sure. Your Honor, can we turn on the projector?
Can?
Is that an accurate depiction of Mr. Melton's hands?
Yes, sir.
So you say this is an abrasion from punching a wall on the inside of his thumb?
I don't have a pointer, but if you look over to the index finger, the ring finger and the next finger over it, that's what I'm calling abrasions right there. There's some other stuff on there that are nicks, scratches, things of that nature, but that's what I mean by abrasions, just that larger hit of something of that nature.
And this is my follow-up question. Sure. Did you confirm that Mr. Melton, well, let me say this. Mr. Melton told you on the 21st that he punched the wall. Is that right?
That's correct.
You all didn't take pictures of the wall until 2 days later. Is that correct?
I believe it's the 23rd when I went over there.
Correct. Did you confirm with anyone else that Chris Melton punched the wall and that's where those injuries came from?
I did not, but I believe somebody talked to his roommate in one of the reports.
Well, he stated that his roommate wasn't present when it occurred, officer.
The only other person that would have been in the house is just the two of them then.
So you don't know if they talked to the roommate, is what you're saying?
No, I'm saying somebody else did, but I did not talk to that roommate.
Now, on January 23rd and 24th, 2001, you obtained a hair sample from Chris Melton. Is that correct?
Yes, sir. I believe that's correct.
And this was done with Detective Newton?
Yes, sir.
Do you recall requesting and obtaining a court order for phone number 678-725-4136?
I believe that was the 24th that I did the hair samples. Is that correct? Before I said yes, but I want to make sure I'm on the same page with
That
you.
is correct. I have the 23rd and 24th.
Okay, the 24th, I have the 23rd, 24th written in there, but I just want to make sure that's the date you're talking about.
That is fair.
What you're looking at?
No, sir, just my notes.
Okay. Yes, sir, we did do hair samples on those days.
Okay. And you also obtained a court order for phone number 678-725-4136. Is that correct?
If I signed for it, then yes, sir, I did. I don't have a signed copy of that with me.
Would you like to see it?
Yes, sir.
Your Honor, after this, can we take a break just in case the jurors need to use the bathroom?
And just let you keep going, Mr. Cruz.
Can you put those in order for me, please? With the stickers on the front page. Thank you. All right, is it okay if I approach you and show you the court order?
Yes, sir, please.
You're welcome.
Yes, that's my signature.
And that number was for, excuse me, you recognize that document, you recognize that court order?
I do recognize the court order and my signature, yes, sir.
Okay. And the 678-725-4136 number belonged to Mr. Melton's cell phone, is that correct?
From my recollection, I believe so. I can look back at my notes, but I think that's what he gave me.
And I believe it's listed in the court order itself, officer.
Yes, sir, but I want to make sure that's the same number he gave me at the interview. Is that
Understood,
understand
understood,
what I'm saying?
understood. I do.
Okay, hang on one second. But I believe you're correct. You okay? I believe that's his next deal, yes, sir.
Okay, excellent. I'm waiting on the state to review some documents I gave them. May I approach you?
Yes, sir.
The document? Thank you.
Judge, can we approach about this briefly?
Do you recall the records that you received in response to the court order?
I do not recall them.
Would seeing them refresh your recollection?
It might. Well,
May I approach you?
yes, sir. It looks like what we used to get faxed to us when we put these things in.
Do you recognize those particular records?
I'll take your word for them. The document you showed me a minute ago was my signature for the request.
So I'd like to talk about those records, okay?
Okay.
And Your Honor, I am not tendering the records into evidence, but I would like to mark them for the purpose of the record. Is that okay?
I'm going to object, Your Honor. The witness has indicated that he doesn't have necessarily a direct memory of these records, but more importantly, as we discussed at the bench, they're not admissible in the manner that Mr. Cruz is trying to admit them at this time, and therefore they can't be testified to as far as contents from them in front of the jury.
That is correct. I'm going to sustain that objection.
Yes, ma'am.
Okay, thank you.
On January 21st, 2001, you spoke with a young lady by the name of Miss Laura Sherling. And that's your January 22nd, 2001 report. And it's page 104, first paragraph, first sentence.
Okay, I don't have the 104 numbers. I just have some of my case reports. What was the name again you gave, sir?
Lauren Sherling.
Yes, sir.
Okay, and that interview with Miss Sherling was recorded, is that correct?
Yes, sir.
Okay, and Miss Sherling is a former co-worker of Miss Baker?
Yes, sir.
All right. I have no other questions for you. I want to thank you so much for your patience and your time and your service to this nation. Thank you.
Okay, thank you very much, sir.
Any redirect, Mr. Yalamanchelli?
I do, Judge. Mr. Ricketts, I want to go back and talk to you about some answers that you started during cross-examination before being cut off. Mr. Cruz asked you a series of questions about whether you recall certain sporting events that occurred back in 2001, the Super Bowl, the World Series, things like that. And then you began to give an answer that talked about the differences between this horrific crime and those sporting events in your mind and your ability to recall certain facts.
Yes, sir.
How is it that the murder of Miss Baker is different than the Super Bowl or the World Series from 2000 and 2001 to you?
From the fall of 2000 to 2001, unfortunately, I worked numerous homicides and then a serial rape case, and in this case, those incidents leave a lasting impression, if that makes sense. So it's not something that you forget. Now, when you read over your reports and records, you remember it. Those small things come back, the details come back. When you start reading back through your reports, it opens up stuff, if that makes sense.
Yes, sir, it does. There was another question where you started to give an answer and Mr. Cruz cut you off and then withdrew his question. It had to do with you beginning to talk about what you would have done if you had noticed a bunch of things or a thick coating on Mr. Melton's hands. Do you mind telling the jury what you would have done?
Objection. That was drawn out on direct examination, not cross-examination. Mr. Yalamanchelli asked him what he would have done if he saw items on his hand when he was fingerprinted. So I would ask, I would object to that question. That was nothing that came up on cross as far as what he would have done. That was direct examination.
Okay, what is your specific objection, though, Mr. Cruz? Mischaracterization, perhaps?
Characterization and relevance. It doesn't follow the line of cross-examination.
All right. Mr. Yalamanchelli, you care to respond to the objection?
Yes, Your Honor. I've got it in my notes underneath Mr. Cruz's cross. Obviously, the court will recall that in whatever way the court recalls it. But Detective Ricketts was in the process of explaining what he would have done if it were some kind of thick coating, and then Mr. Cruz stopped him in his answer.
Right, I'm going to allow it. You may continue.
All right, so Detective Ricketts, I'm going to kind of ask you that question again. During cross-examination, Mr. Cruz stopped you in the middle of your answer as you were discussing what you would have done had you found a thick coating of things on Mr. Melton's hands. Can you explain to the jury what you would have done if you had seen that?
I'm going to overrule the objection. You may continue.
Well, number one, if it's a large amount, you can't be fingerprinted. So that would have interfered with just the fingerprinting if there was a large amount. Now, on the back of the hands or whatever else, there wasn't enough stuff on his hands to cover up anything that might have been there. You could easily see it. So if there would have been things that we would have had to take pictures, and then we'd have had to move with Lieutenant Durham and some other ways that we would have gone on from that moment on. But those were not noticed. And again, I'm literally holding his hand while I fingerprint him. I mean, my hands are holding finger by finger as I flip that hand over. I'm having to hold his hand.
Also, during your testimony, after the distance from 160 Fawn Drive to Mr. Melton's parents' residence was established, you testified to a timing run that was done by ACCPD at the time. Is that correct?
Yes, sir.
And I just want to clarify that because I feel like it might have gotten lost in your testimony and questions coming in while you were talking.
Objection, Your Honor. This calls for hearsay. We explicitly did not ask him about the time stamp. We disagree with the time stamp that was given. But the reason we didn't ask that is because we know under the law that is hearsay.
All right. Any response to the objection?
Well, Judge, this is a response that was given to Mr. Cruz's question about what was done. The response is about what ACCPD did at the time. And the answer was given during Mr. Cruz's cross-examination. I'm just going back to talk about that answer. That answer wasn't objected to or asked to be struck or otherwise identified as hearsay by Mr. Cruz at the time. So it's in evidence, and I think it's an appropriate grounds for redirect examination.
Right. Yes, sir.
I would just ask, Your Honor, I'll leave it to the discretion of the Honorable Court, but if that door is open, the reason I didn't go down the impeachment route with that line of question is because I wanted to follow the law. That isn't appropriate to bring out of a witness. That was non-responsive to my question. But if the state is allowed to go down that line of questioning, I would just ask the Honorable Court to allow us to follow up with that line as well on recross examination.
Okay. Thank you, sir. The objection was with regard to hearsay. I don't find that this question is going to elicit hearsay. I'm going to allow you to ask it. Certainly on any recross, we will address any issue that the state might object to, and we'll take it up again if we need to. But you may go ahead.
All right. And so, Detective Ricketts, what was it that you stated was the time period when ACCPD or law enforcement did a test run back in 2001?
It was over an hour with traffic. So it took them just a little bit over an hour to make that drive.
Okay. I want to talk to you just really briefly about your familiarity with some of these areas in Loganville, Grayson, Truck Customs. During your testimony, you made reference to the fact that you drive that route at least semi-frequently. I'm not asking you an address where you live, but in general terms, what area of the state of Georgia do you live in?
Toward Gwinnett County, that way off 78.
Are you familiar with these areas that we've been discussing, kind of independent of your investigation?
Objection. Gwinnett County to Athens is irrelevant to any facts that are already in evidence in this case.
All right. There's a relevance objection. Mr. Yellman-Chili.
So is the objection to the follow-up question that I asked or the answer that Mr. Ricketts gave to the previous question? I'm just not sure.
Sure. Go ahead.
To the follow-up question, Your Honor.
All right. Do you want to respond?
Yes, I do, Judge. The follow-up question was, are you familiar with the areas that we've been discussing as it relates to Loganville, Truck Customs, and Grayson? So I think that is relevant.
Okay. Is that your objection, Mr. Cruz?
Not the follow-up question, Your Honor. The follow-up, he asked him about Gwinnett County to these parts around here, Your Honor. That is not relevant. Mr. Melton stayed in Loganville, which is outside of Gwinnett County. So Gwinnett County to Athens is irrelevant in this case.
Okay. Let me just say this. I think you're referring to the question before the follow-up question, but we can talk about that. I think that is your objection. All right. And so that question has already been asked and answered, but let's let the state, if they choose to, respond to the objection about relevance when you asked about the Gwinnett County area. Do you care to respond?
Yes, Judge. I think Detective Ricketts, during cross-examination, indicated he was familiar with that general route, and now I'm going back to establish why it is that Detective Ricketts is familiar with that general route. And then, obviously, court heard the follow-up question, which had nothing to do with Gwinnett County. It had to do with his familiarity with these specific areas that we've been discussing.
All right. I'm going to overrule the objection. You may continue.
So, Detective Ricketts, I'll go back. I'll ask that question again. So, as it relates to the discussions we've had about Loganville, Truck Customs, and Grayson, are you familiar with those areas?
Yes, sir. It's like a small triangle there. We're there together. Loganville, Grayson, all those little areas are very close to each other, like in a triangle.
And so when you say very close, let's just talk about Loganville and Grayson. How close are we talking about?
5 miles or so. I mean, they almost touch each other, I would say.
Okay. Repeatedly during cross-examination, Mr. Cruz made reference to you being unable to obtain documents from Nash Plumbing and some of these other locations that both Mr. Melton and Mr. McCurdy said that they both went to. I just want to clarify, because I think sometimes unable can leave a certain impression. Did you ever actually even attempt to do that?
I did not.
Okay. So is it fair to say that you didn't ask and then someone wasn't able to produce them? It's just that you yourself never asked.
That's correct.
Okay. Also want to talk a little bit about differences in timelines. And obviously, Mr. Cruz had Mr. Hill write some things on the flip chart. I don't need the flip chart. Detective Ricketts, in your having received all that information from Mr. Melton, Mr. McCurdy, and Mr. Teeter about Mr. Melton and Mr. McCurdy's whereabouts on January 19th of 2001, was there anything that you received from those individuals that caused you concern about the integrity of those statements regarding where they were?
No, similar to the whiteboard, we use a similar thing, except we go across. And on any kind of investigation we started back when I did those, and even to this day, we would go across with a timeline, and you get the second subject, and you go across with a timeline, and you get the third and the fourth and the fifth, and you start looking for consistencies and inconsistencies in those timelines. In this first 72 hours, just because Chris came back and remembered the bank, again, like I said when Mr. Cruz was talking to me, that's not abnormal for the timelines not to be minute by minute, to be some overlap. So on that first 72 hours, we weren't concerned about that overlap. We weren't concerned about any of that. We wanted to move on toward getting fingerprints, DNA, and push the investigation that way. So we were trying to secure all that, but that timeline didn't give me any pause at the beginning. Now, we've had investigations before, just to give you a this or that, investigations where as soon as you put the timelines on, you're like, they're in another world. So when they're close together and you can put that line close together on a board, you can kind of work that out. And I wasn't, in that first 72 hours, I was not at all uncomfortable in what we were doing.
And so as far as these variations that you saw and that we've talked about between Mr. Melton, Mr. McCurdy, and Mr. Teeter, would those be consistent with variations that you had experienced in other investigations that you had?
Yes.
Okay. Was there anything unusual to you about those things not being minute for minute exactly the same?
In the first 72 hours plus, no. In that first 72, 96 hours, nothing was out of that realm of that I was concerned about, that I needed to move on quicker, if that makes sense.
And so I'm going to ask you, Mr. Cruz asked you about things that Mr. Melton's father may have said or not said to law enforcement. Was there another law enforcement officer who followed up with Mr. Melton's father?
In my recollection, yes. Lieutenant Durham was sectioning out what needed to be done. Again, as for this case, on that weekend, that Friday, Saturday, I was scheduled to be back going to school on Monday, leaving the state. Canceled that trip because of Friday. This was way more important. But Lieutenant Durham was assigning people to do those tasks, to do those follow-ups. So yes, sir, somebody was assigned to do that follow-up and talk to that person.
Do you believe, one second. Do you believe that seeing a police report from Rebecca at the time Taft would help refresh your recollection?
Yes.
Relevance, improperly attempting to refresh a witness's recollection are my two objections. So relevance, and improper attempt to refresh recollection. Those are my two objections.
Okay. I'm not sure I know what you're trying to refresh. You didn't finish the question. So he's made two objections.
So first, as to the relevance factor, this would be information that Mr. Cruz solicited on cross-examination about statements made by Mr. Melton's father to law enforcement regarding Mr. Melton's whereabouts. So that's one, relevance. It is absolutely relevant, even independent of Mr. Cruz's questions on cross-examination, but certainly at the point that the information is solicited on cross-examination, it would be relevant in a redirect. Improperly refreshing the witness's recollection, what the law says about that is that a witness's recollection can be refreshed with anything, including, things that might not make sense. I could hand him a pack of exhibit stickers and ask him if it refreshes his recollection, and it may or may not. So I don't think that that's a valid legal objection in this circumstance.
Yes, sir.
I have one. Double hearsay. Double hearsay. It's a report from one person that he's going to show the detective to ask, or I guess refresh his recollection as to what a third person said. So I'll add that objection as well, Your Honor.
Well, and Your Honor, if I may respond to the new objection. So once Mr. Cruz solicits that information on cross-examination, I believe he's barred from raising an objection during the redirect examination as to that same information.
Yes. One more time. Yes, sir.
I know Your Honor knows the law. I'll just leave it there.
Okay. Thank you, Mr. Cruz. All right. With regard to the relevance, I certainly find that this is relevant based upon both examinations this court has heard with regard to this witness. I'm going to overrule the relevance objection. With regard to the refreshing recollection, you are entitled to refresh this witness's recollection if it does. So you may refresh his recollection with anything. We're going to take it from there, and then I'll make a ruling on the hearsay objection. So you may go ahead with the refreshing recollection if you can.
Thank you, Judge. I'm going to show Mr. Cruz a copy of the police report from May 4th of 2001.
Judge, I am going to object. I don't understand how another detective's police report will refresh this witness's recollection. The foundation hasn't even been laid. He never asked the question, do you remember Rebecca's report from May 4th, 2001?
Any response to that objection before I make a ruling?
No, Your Honor.
All right. The law is that if a witness does not recall, the state can ask, or the defense, any party can ask to refresh a recollection. It doesn't mean that the witness's recollection is going to be refreshed, but any party is entitled to use a document, an object, an audio recording, a visual recording, anything can be used to attempt to refresh a witness's recollection. I'm going to allow the state to attempt to refresh a recollection, and we're going to take it from there. So I'm going to overrule your objection, allow you to continue, and then we'll take it from there. I'll rule then, if necessary, on the other part of Mr. Cruz's objection.
Thank you, Your Honor. Detective Ricketts, I'm going to hand you this, and for the record, it is a police report from Detective Rebecca Taft from May of 2001. If you would, please review it, and once you've had a chance to review it, let me know.
Yes, sir.
Have you had a chance to review that report from Detective Taft?
Yes, this was one of the assignments.
Hold on one second before we get into any other testimony. Has reviewing that report helped refresh your recollection as to what other law enforcement may have done related to George Melton, Mr. Chris Melton's father?
Yes, I knew a detective had gone and interviewed them both. I just couldn't remember if it was her or John or Painter. Not Painter, but anyway, I knew it was one of the ones, but yes, this is the recollection of the report that I remember seeing.
Okay, all right.
All right.
So I'll come get that back from
All right, and at this point, since the recollection has been refreshed, I'm going to send the jury out for just a moment and take something up outside your presence. Please don't discuss the case. Thank you. Be seated. Thank you. Yes, of course. All right. I wanted to take this up outside the presence of the jury in the event that the information you all are arguing about is something that is not admissible, and I don't want the jury to hear it. So I'd like to hear what you all are arguing about.
Thank you, Your Honor. So, Judge, if I could retrieve the
May?
I'm sorry. Thank you.
Your Honor, on cross-examination, Mr. Cruz elicited information regarding statements that Mr. George Melton, who is Chris Melton's father, either made or failed to make to law enforcement, with the implication that Mr. George Melton never corroborated Chris Melton's whereabouts at his own home on the morning of the incident, which is what is contained in Detective Taft's report, who I'll note for the record is deceased. And so based on the fact that Mr. Cruz is soliciting this information, which, in its outset, obviously Mr. George Melton is also deceased, so it would be a hearsay statement. However, once Mr. Cruz, as the opposing party, has elicited hearsay statements, then he's then barred from raising an objection to the other party talking about those same statements. And so what we've endeavored to do is we have reached the point at which Detective Ricketts has had his recollection refreshed about these conversations with George Melton and who had them. And my next series of questions to preview them for the court would just essentially be, you know, are you aware of anyone in law enforcement that had a conversation with George Melton? Did they talk to George Melton about Chris Melton's whereabouts on the morning of January 19th of 2001? And what information did Mr. George Melton give about Mr. Chris Melton's whereabouts?
All right. Thank you. Mr. Cruz, do you care to respond, sir?
Yes, ma'am.
Go ahead.
So I wholly disagree with the state's position that if, and I'm not saying this is the case, and I get into the hearsay piece, if hearsay is elicited, they could then bring in a report that's essentially double hearsay. But in regards to the hearsay portion, Your Honor, I didn't elicit hearsay. I asked the officer about what was not said. I didn't ask the officer about a specific statement that was said. So my examination questions were not hearsay because I didn't elicit a statement. I just simply elicited that Mr. George Melton did not say a particular thing. As far as what the state is trying to introduce, and I've said it before, I believe the state is trying to use this witness to, and I don't think it's intentional, it flows from the act. We have a right to examine the witnesses, to cross-examine the witnesses. With prior witnesses, it has already come up regarding the statement to law enforcement on May 4th, 2001. However, because Detective Ricketts, during my examination, he explicitly made clear, and correct me if I say anything wrong, but he explicitly made clear that his involvement from this case was January 19th to January 21st. And I limited my questions to your involvement. So now to go 4 months later and say, well, let's talk about Detective Taft's report and what George Melton, one level of hearsay, told Detective Taft, that's the one level, and then Detective Taft put it in a report, which is the second level of hearsay, and then to ask this witness to testify about same, Your Honor, is improper.
Mr. Cruz, let me ask you a question.
Sure.
When you asked a question to this witness about statements allegedly made by George Melton, did you phrase it in the time frame that you've just suggested, the 19th through the 21st, or did you just make a blanket question about Mr. Melton?
So the officer limited his answers to that window.
All right.
So the officer said during my involvement in this case, which we established was January 19th to January 21st. And please correct me if I misstate anything.
Well, that is how he responded.
Correct.
All right. Thank you, sir. Mr. Yalmanchili, anything else that you would like to say?
I do believe the question was stated in such a way as to go beyond whether a statement was made directly to this witness, one, or two, limited to the time frame of January 19th to January 21st. That's my recollection of the question, Your Honor, but of course the court will have its own recollection.
And just to add, Your Honor, my questions are not evidence. It's the witness's answers that are evidence. I didn't elicit anything from this officer that Mr. Melton, in the course of this investigation, did not say X, Y, and Z. If the state would like to get into that and give us an opportunity to cross-examine whichever witness it may be, I believe he said Detective Taft has passed away, but she had a partner with her. So if the state wants to call that individual in and we get into those statements, I think that's fair, I think that's proper. But to use Detective Ricketts as a surrogate to get in inadmissible hearsay or to counter anything we bring out from Detective Ricketts' personal involvement in the investigation, we think that is improper. We have no way to cross-examine Detective Ricketts about what George Melton told Detective Taft. And he couldn't lay a foundation for the audio recording either way. So we would be handcuffed in the sense of we can't confront those statements, Your Honor.
All right. Thank you, Mr. Cruz. So I think there are a number of issues going on here. And one of them is semantics. And it is improper for one party to say or to argue that the other party is not entitled to go into something that was raised because one party used the word not or didn't use the word not. And so I just want to make a statement about that. It is not, this is not a court of, well, I'm just going to say it that way. I'm going to respond to what I was just going to say in a minute. With regard to the defense's comments that they only limited their questions to the 19th to the 21st, that is not terribly accurate in how the cross-examination went. The cross-examination was directed in a way that forced this witness to continually remind counsel that he was only referring to the 19th to the 21st. And so to argue that the defense has only asked questions about that period is inaccurate in terms of what we've been hearing for the past 45 minutes. And so I want to respond in that moment. The law allows either party to go into something that the other party has raised without an objection in order to respond properly. The law allows that. And so Mr. Yalamanchili is correct about his ability to cross-examine this witness. On the document that refreshed his recollection, you will have every opportunity, Mr. Cruz, to cross-examine him on how he had his knowledge, if he has the knowledge, and all of those things. But the defense did bring it up, and so I'm going to allow it. You may bring the jury back in. All right, you may be at ease.
This line of questioning with, I respect the court's ruling, so I'm not trying to challenge that. I just want to put on the record that a prior witness came in and testified about this particular information as well, Your Honor.
You have the floor.
Thank you, Your Honor. Detective Ricketts, before we took that brief break, I believe you had just reviewed a police report from Detective Rebecca Taft from May 4th of 2001. And I'll ask you the same question I just asked you previously. Having reviewed that report, did it refresh your recollection as it related to George Melton's statements to law enforcement?
Yes, it did refresh my memory on that, Becky was the one that went out to the residence, interviewed the family, and got those timelines on for the family and for the time that they got up in the morning and at the time that the helper showed up to, because Josh got there that morning.
And so as it relates to the date that we're discussing, are we talking about the night of January 18th, that Thursday, into the morning of January 19th, that Friday?
Correct. She had a time when she got up and then he was up that morning.
Okay. And I want you to, let's limit your testimony to what George Melton said. As it relates to George Melton, did he make any statements to law enforcement regarding Chris's whereabouts on the morning of January 19th of 2001?
He did. He said that he was there on the morning of the 19th when Josh showed up to pick him up and was there that morning from, I think, the time frame I saw was like 6:15 that morning.
Okay. And when you say there, where are they referring to?
At that residence.
Okay.
Home.
And would that be the residence of Mr. Melton's
Yes,
mother and father?
That's correct.
Okay. Detective Ricketts, I'm going to hand Mr. Cruz what's been marked as State's Exhibits 149 through 157, and after he's done reviewing them, I'll hand them to you.
Yes, sir.
Detective Ricketts, I'm going to hand you States 149 through State 157.
Yes, sir.
Just take your time, flip through them, let me know when you've had an opportunity to review them all.
Yes, sir.
And kind of collectively, not individually each one, but generally, what are all those pictures?
These are the photos that Detective Newton took while we were at the hospital at Athens Regional, where the blood work was done. We had Chris remove his shirt, and we took pictures of his upper torso, his arms, his back, his neck, pretty much every part of his body except the groin. We had him pull his pants really up in his underwear so we could see pictures of his legs, feet, back of the feet, everywhere on his body, and just mark any abrasions or scratches or anything that we saw on the body.
And those images, do they appear to be true and accurate depictions of Mr. Melton's appearance in the photographs taken on January 21st of 2001?
Yes, sir.
Okay. Judge, I move to tender those at this time.
Any objection, Mr. Cruz?
No, ma'am.
They are admitted.
Your Honor, if I could publish them on the L notes of the jury.
You may.
And State's Exhibit 149, I'm putting that up on the Elmo. What are we seeing for purposes of the record? Obviously, the jury can see it themselves, but what are we looking at in State's 149?
We're in the clinical room where the where the phlebotomist was. This is the front picture of the torso. In another photo, there's a minor scratch on the left arm right there of the patient, or I'm sorry, I flipped at the EMS mode. I work EMS, so I apologize. On Mr. Melton on his left arm there, and it's just the front of him with his shirt off.
Okay. And then I want to point out one other thing. You said the word phlebotomist. What is a phlebotomist?
The person who does the blood work made pulled the blood from the person.
And I'm pointing this right here in the corner right there. Do you recognize what that is?
Yes, sir. I believe that's the injection point right there.
Okay.
She pulled them both out on the ACs right there.
All right. And so the injection point, would that be where the phlebotomist accessed his vein? Or?
Yes, sir.
Okay. State's Exhibit 150, what are we seeing here?
Just the lower part of the torso from the nipples kind of like to that pelvic line there. Just again, looking for any types of abrasions or scratches.
$151, what are we seeing there?
Lengthwise from the scalp down to the belt line, back of both of the arms. Arms are left straight down to the side, so you can see the back, and in the other photo, you can see the straight side of the front of the arms.
State's Exhibit 152.
Just a look at that side from the patient's left, or I'm sorry, from Mr. Melton's left. I apologize.
State's 153.
Mr. Melton's right side.
State's 154.
Front of Mr. Melton's legs with his underwear pulled up as much as possible, just to have a look at his legs.
Okay. State's 155.
Back side of the legs from the knees down to the ankles of bottom of his feet, or the top of his feet.
State's 156.
The front of the feet from the kind of top of the shin bone down.
And State's 157.
I believe that's his left arm, and that's the little mark that I was talking about there on the side.
Thank you, Detective Ricketts. I don't have any other questions for you right now.
Cross-examination or recross, Mr. Cruz.
Sure. Your Honor, based on what was brought out on redirect, it's going to take some time. Can the jurors get lunch and I can start after their lunch?
We have everybody at the bench for a moment.
So Detective Ricketts, I'd like to talk to you about a couple of things you discussed with the state, okay?
Yes, sir.
All right, first, let's talk about the over an hour with traffic to drive from Mr. Melton's home to Ms. Baker's home, okay? Can you tell us the speed that the individual was traveling?
I cannot.
Okay. Can you tell us how long traffic was stopped?
I cannot.
Okay. So that over an hour, it doesn't account for the various conditions that led to that amount of time. Is that right?
No, sir, it does not.
Okay.
That was just in general.
Yes, sir. They also talked to you about the meeting that Detective Taft had with Mr. Melton's parents. Is that correct?
That's correct.
And we've already agreed that this murder happened on January 19, 2001.
Correct.
All right, that meeting occurred on May 4th, 2001, correct?
Correct.
So it was about 4 months after this has taken place. Is that right?
That's correct.
Okay, and Mr. Melton had been staying at home for those 4 months. Is that fair?
I don't know if I can answer the question. That I'm sure he moved out of his apartment, which he said he was going to do, but I don't know if he moved up there or not. I don't know when he did it. I guess you should say that.
And I show you the same report that the state showed you?
Yes, sir. Thank you.
And it will be in the second paragraph, officer, I believe, either one of the first two sentences.
Okay, so you're talking about from right here?
The second paragraph?
Yes, sir. And this was before Tara died.
Correct.
About 2 weeks before Tara died, he had been living there. Yes, sir.
The parents said that Mr. Melton had stayed with them about 2 weeks before Tara died.
Correct.
So Mr. Melton, you would agree, had 4 months to tell them his alibi. Is that right?
4 months before they were interviewed?
January to May. He had between January and May to talk to his parents about where he was and his whereabouts.
No, because on the tape, on the interview I did with him, Mr. Melton told me that he'd been living up there for that whole week. Now, they went up and said the 2 weeks, but I know probably, I won't speculate, Chris used to come back to Athens on the weekend and stay in order to be closer. But on the tape in the first interview, I believe it's in my notes, Mr. Melton said that he had been with him most of the week while he was starting the business. So that 2 weeks is correct. The time frame is correct on that, but Mr. Melton corroborated to me before that time on the 19th that he had been there almost that whole entire week. So I had a week. Taft says 2, but I knew for a fact on the 19th the week, well, from Mr. Melton's statement, if that makes sense.
That's fair. And I try not to get in other people's statements because they come and testify and they tell the jury themselves. So
That's okay. I
be careful
understand.
with that.
I went around the tree on that one, so
Yes, sir.
I apologize.
No, that's no problem. But I do want to talk to you about a couple other things. So we've established that Mr. Melton was at home with his parents when they spoke with, when his parents spoke with law enforcement on May 4th. Is that right?
Yes, sir.
Okay. Now I want to talk to you about what Mr. Melton told you about knives and Miss Tara Baker, okay?
Okay.
On January 21st, 2001, Chris Melton told you that...
I'm going to object. I don't think any questions came up in direct examination or cross-examination when Mr. Melton testified regarding any kind of discussion about knives.
All right, let me see counsel at the bench, please. May have.
was looking for. I got you.
Now, the state asked you about Detective Taft's interview with the parents. Is that correct?
That's correct.
And you stated that you were aware of her report in her interview with the parents. Is that correct?
That's correct.
Detective Taft stated, unable to locate Nash Plumbing to verify that Josh and Chris were there that morning. Is that correct?
That's correct.
And this was May 4th, 2001. Is that right? She also stated there is no listing in information for them. Is that correct?
To my knowledge from that report, that is correct.
Thank you. All right, no other questions?
Thank you, sir.
Any, excuse me, any redirect, Mr. Yalamichili?
Briefly, Your Honor, and I'm sorry I should have done it the first time. My apologies. Just going to refer to this real quick. In cross-examination, Mr. Cruz elicited testimony from you that Mr. Melton indicated that he and Mr. McCurdy had only known each other for a month, and Mr. McCurdy indicated they had known each other for a year. Do you recall that?
Yes, sir.
Okay. Was that your recollection of the interview?
No, like I said, interview, it was more like a year they had known each other and been working on and off. That when Chris decided to start his own business, he came over to assist from somewhere else. So I think Chris pulled him over there, if that makes sense.
Okay. And so your recollection of the interview is that Chris indicated that they had known each other for about a year. Is that right?
Yes, sir.
Okay. Judge, I don't have any other questions.
Recross, Mr. Cruz.
Yes, ma'am.
Go ahead.
If the honorable court is willing, can the jury go to lunch? Because I think this is going to be a back and forth.
I'm gonna ask you to continue your recross, please. Thank you.
Will do. So it is your testimony here today that Chris Melton stated that he knew Josh McCourty for a year when you interviewed him on January 21st, 2001.
I would say approximate between the interview on the 19th and the 21st. That's what I pulled away from there.
Okay, that he knew Josh McCourty for a year.
Yes, sir.
All right, court's indulgence, Your Honor. Bless you. get into how long they knew each other, I asked you a couple of questions just to be considerate of everybody's time, so we could knock it all out in one swoop. When Chris Melton appeared at the police department on January 19th, he appeared with Josh McCourty. Josh McCourty was present as well. Is that correct?
To my knowledge, I wasn't there when they arrived, and I never saw Josh on the 19th.
Okay.
Like I was saying in my opening, I came up from the other part of Georgia doing a cold case, so I didn't get there till after things had already been going.
So your testimony here today is that Josh McCourty was not at the police department on January 19, 2001.
I didn't talk to him there. I don't know if he took him straight to the scene and then came back over there.
Not did you talk to him. Was he present at the police department on January 19, 2001?
And Judge, I'm going to object, lack of personal knowledge. I think the witness has already said that he never saw him there and he wasn't there earlier in the day. So.
I'm going to allow him to ask the question.
I never saw. I'm sorry. Go ahead.
I would ask the state to make a objection, give the ground, and honorable court rule. I would ask them to stop attempting to coach the witness from the stand, Your Honor.
Right.
Mr. Yalamachili just gave an answer that the witness was about to repeat. So I would ask the honorable court to instruct Mr. Yalamachili, if he has an objection, just state the ground and allow the honorable court to rule.
Judge, if I could just briefly,
You may.
What I did was restate the answer the witness gave to a previous question, and that is the explanation for why he lacks personal knowledge. I would also, strongly dispute the mischaracterization of what we're doing when we're just repeating what the witness has already said.
All right. Thank you. Mr. Cruz, you may continue.
Thank you, Your Honor. So is your testimony here today that you don't know if Josh McCourty was at the police department on January 19, 2001?
Yes, I don't know he was there.
I'm going to play for you. I'm going to bring the computer to you just to make sure you are aware of this recording. And for the purposes of the record, I am going to play from minute mark 0 to minute mark 129. And after you listen to it, I'm going to have some questions for you. to introduce, or I'm marking, forgive me, I am marking minute mark 0 to 129, 1 minute and 29 seconds, as the defense exhibit 46. Detective Ricketts, you had opportunity to hear the recording that was marked as defense exhibit 46. Is that correct?
Yes, sir.
Okay. You recognized your voice?
Yes, sir.
Okay. Did you recognize Mr. Melton's voice?
I did.
Okay. And you recognized that recording as your interview with Mr. Melton on January 21st, 2001?
Yes, sir.
And based on that portion of the recording, was it a fair and accurate depiction of your conversation, or a fair, accurate recording of your conversation with Mr. Melton?
Yes, sir, it was.
And did it sound like that portion of the audio had been altered in any way?
No.
During this interview, you asked Chris Melton what happened to Josh McCourty. Is that correct?
I did.
And you stated that Josh disappeared on you. Is that right?
He did. That's what I said.
Let me put it into context. You stated Josh, he disappeared that night. Where'd he go? Is that correct?
Yes.
I also asked you about how long Chris Melton worked, or stated that Josh, or stated how long he knew Josh. He stated he knew Josh from working at McCart Plumbing. Is that correct?
Correct. That was that year part I was talking about.
Mm-hmm. And he said that one more time.
That was the year part I was talking about. They'd known each other for about a year working at McCart Plumbing.
Chris Melton didn't state he's known him since December, or he's worked with him since December of 2000?
So December 2000, I took from that conversation that that's when he came to work with Chris when Chris started his business, but they had worked together at the other place and knew each other from that.
But you would agree that Chris stated he started his business a week before Ms. Baker died.
He did. He had just started his business up. His business was brand new.
Okay. So you took from Chris saying he knew Josh from December of 2000 to mean that they started working together in December of 2000.
I took from that conversation that they had worked together elsewhere, and then when he started his business, Josh came over with him.
And a week before January 19th would have been January 12th. Is that right?
Yes.
No more questions, Your Honor.
Any redirect of this witness?
No, Judge, we'd ask that he be excused.
Any objection from the defense?
We have him under subpoena, subject to call.
All right. You are free to go, sir, but you are still under subpoena by the defense.
Thank you, ma'am.
You're free to go.
Your Honor, I would need to get contact information from Detective Ricketts.
I'll certainly let you have a conversation with him. Absolutely. All right, ladies and you may step down. Ladies and gentlemen, we're going to take a lunch break until 2:30 this afternoon. It's a little bit longer. Please don't, of course, discuss the case. Go to any place that you may have heard about. Please don't do any research other than that. The deputies are going to escort you to the elevator and to the parking deck. Enjoy your lunch. We'll see you all at 2:30. Thank you. Y'all may be seated. Deputy, do you mind shutting that door for me? Thank you. All right, Council, I want to take up a few things before we take our lunch break. All right. I want to just take up a few things. I know the state and the defense need to get together to talk about the statement and whether you all agree on certain eliminations or redacting of that audio and video. So let me know if we need to take up anything, obviously, before you intend to play it. I know that at times tempers run high for both parties, and I'm going to caution both parties to avoid commenting and making comments that are not appropriate. You got to ask questions. I mean, I know sometimes it's hard to help because, again, y'all are tired. You're both doing important work, but you've got to stop commenting, and this is for both parties, in an inappropriate way about things that are not appropriate at that moment. Save it for closing arguments. All right, number two, Mr. Cruz. We had a, and you don't have to stand, sir, that's fine. We had a conference at the bench about telephone records, and I ruled that they were not admissible based on the law. And then you directly went to the stand and tried to get into them. And I'm going to caution you not to do that. That's not appropriate, and you know that.
And just to state it in my place or to give the Honorable Court explanation, I understood the Honorable Court's ruling that I couldn't introduce it into evidence, and I was not going to attempt to introduce the records themselves into evidence. I intended to speak with the officer about the records, but if that was an error, I apologize, Your Honor.
It was.
Yes, ma'am.
It was way too close to the line of ignoring the court's ruling. All right. And the third thing is, and this is directed towards you, Mr. Cruz, this court is responsible. You don't have to stand, sir. This court is responsible for controlling the courtroom and the jury. And it is my job to control the courtroom and to decide when breaks are taken and things of that nature. And I'm going to ask you to stop commenting on whether the jury needs a break or things of that nature. That's for the court to do. And I just, we all need to stay in our lane as far as that is concerned. All right, thank you. Other than that, we are adjourned, and I will see you all at 2:30. Thank you.
Thank you, Judge.